Good morning, Bougie Gang. How's it going, guys? Good morning, good morning, good morning. Let me go to the monitor because we got a new member. Good morning. Good morning, good morning, good morning. Y'all got here early. Bible Lady, good morning. Sonia, J. Blake, early morning vibes. Mimi, Mocha, Peach Tea, I am Coco, Mai Tai, India, Michelle D. Good morning. Rita, Lady V, Miss HLS, Tamaria, L. Is it Tamaria or Tamaria? Yeah, I think probably Tamaria. That's what I'm guessing. Tamaria or Tamira. Butterfly 23, I see you. J Fox, Queen Lily. Hey Boo. Hey. Queen Lily just got awarded some sort of some sort of recognition. So shouts out to Queen Lily doing the work of the people. I'm gonna skip all the way down. I see Zola Vans in the house. Yes. One of our fellas from the YouTube streets, okay? One of the guys of Bougie Gang. Hey. And so I'm going to also say good morning, Miss Donna. Hey, guys. Good morning. Good morning. Good morning. Good morning. I feel like, damn, I'm close. Good morning. Let me sit back a little. Girl, we're in court today, okay? We are in court today. Crafting with your flamboyant creator, okay? Miss HLS, Tamaria, Butterfly, J Fox, Miss Lily, Tell the Truth, Grown and Nosy, okay, Elite Diva, Summer Breeze, okay, Glorious Love, good morning, sis. Early morning, I think for the 2 times. Good morning, good morning, good morning. Guys, I am noticeably absent. Can you please send a sick note? Well, we're not going to send a slick note. Me and one of my good friends, we used to call it calling out slick. In our 20s, it was like we would be at the club on Thursday night and it was so obvious. But in your 20s, you're stupid, right? So we would call out slick or go in at lunchtime because sis needed some rest. I was out till 3, 4 o'clock in the morning, right? That's what you do in your 20s if you're not raising kids, which I was not. Got to go out and have fun and business after hours and go to the club. And because, it would start on Thursday night for us. She still sleeps, sis. I'm up. Oh, aren't you sweet? That's why she stays beautiful because she gets all of her good beauty rest. I went to sleep early last night. Let me tell you, I was wide awake at 5 o'clock. But yes, please do give Miss Donna my best wishes. I love me some Miss Donna. So I hope Miss Donna's tuning in over here because she's gonna like it. Girl, mom killed her boyfriend, okay? And she's trying to get up out of it. Let's make sure we're not missing a thing. Court TV they don't have the feed up yet, but it's getting close. They're 5 minutes to going live. Law and Crime, I don't know why they don't put their live placeholders up. During the trial, if it feels like there's some lag problems, then I'll probably take myself off the screen because obviously this takes additional bandwidth and I see it's already a little bit slow. So I might take myself off. I just wanted to say good morning. I'm here. Once things settle a little bit more, then maybe I'll come back on camera. Let me see. Let me see if I switch to Google Fiber, will it make a difference? It was lagging this morning, but we shall see. Maybe this is better. Oh yeah, this is like I can see myself in real time. Spectrum was lagging a little bit. If you notice anything weird, let me know and I'll just switch between providers. Oh, thank you. She loves you too. I'll make sure she gets the message. Absolutely. I hope you have a wonderful day, sir. I know I got to get back over to Love Lies and Lace Fronts, but this, I'll be over there tomorrow for sure, so we can get caught up because I know we got renovations to talk about. Um, sis clearly she knows what she's doing, so we're gonna talk about it. I had my weekly 45-minute massage yesterday. Went to bed early with my phone underneath my pillow and my wig on my other pillow so that I would be on time for court. Okay, sis. Girl, yes. Hey, Miss HLS. Good morning. I think I said hi to everybody. Jay Blake. Is it Alika? Alikia, maybe? Alika or Alikia. Good morning, sis. How are you? Um, Nico B100. Okay. Did I get that right? Darla, I see you. Where was it? I saw Darla. Here you go. Hey, good morning. Good morning. Good morning. Good morning. Sanders, good morning. Good morning. Good morning. I think I saw everybody. Yeah, so far so good, right? It's okay now, but if it starts lagging, I'm going to have to sacrifice. But I wanted to be in the square. I wanted to be on site, okay? Let me see. Yeah, let me get here in the middle. Y'all, yesterday when Mr. J broke it down, when Mr. Owens was okay, can we talk about the highlights from yesterday? Let me write them down. Can you just start dropping them? My first highlight from yesterday was Sarah. Now, this is for what you did to me. Sarah, you better shut up. Sarah, that's my name. Don't wear it out. Shut up, stupid. When Mr. J said, okay, this is the case, baby, they better not press him. Because let me tell you something. If you press Mr. Will J too hard, he is going to get real nasty with you. And he's going to say something that I'm almost really sure you're not going to like. Mr. Owens and Mr. Henderson, stop better trying to be cute with Judge Kranek because Mr. J is going to drag their client. He's not even going to worry about them. He's going to just go ahead and drag Sarah for the fun of it. Like, snacks denied. Okay. Snacks denied. Okay. All right. So it was Mr. J and that old nasty drag of Sarah's defense. Ooh, he dragged it. Ooh, he dragged it bad. It was the snacks. Judge Kranek said they provide adequate meals and you're not getting over and above. Do you know so Judge Kranek doesn't make the decision, right? He said he was going to call the captain. So who would that be? Was it Captain Don Giovanni or Captain the lady who was on the phone when they were asking for all the other stuff last time, right? And then the lawyer, when he said adequate meals are already being provided and she's getting 2 sack lunches in the basement where she's housed, waiting, I almost fell out, okay? I fell out. And you already know that ma'am was like, maybe it's Captain Di Giovanni, right? It was something like that, a very long Italian name that started with a D, right? I feel like it was D Giovanni. In my brain, when I'm remembering the letter that I saw her write, I think it was D Giovanni, right? Who sounded like she was from Staten Island, okay? Um, Girl, they get a peanut butter and jelly sandwich down in the basement, okay? Girl. I would have been over at the state prison by now. They say state is better than jail because conditions in the jail are not good, but I don't know. She's probably gotten used to it. Anyway, so snacks denied. Um, it's the Richardson hearing that's getting ready to happen. Um, Let me reset my other page just to make sure we're not missing anything because I don't know why if Law and Crime just doesn't put their stuff, their placeholders, and I'm a member on Law and Crime too. I'm like, Where's the damn placeholder? I know I didn't do mine for a minute, but damn, I don't have 11,000 people in my live every day. You know what I'm saying? Like on one channel. Let's be real here. They had so many people in their live yesterday and they were not lacking over at Young Thug or at any other the other like, you know what I'm saying? Like they got baby, get your damn placeholders up. They're probably trying to set it up now. Let me check on X and see what ma'am is saying. It's like, ma'am, maybe I'm gonna have to message her and say, "Hey sis, can you managing editor of Law and Crime, can you guys put your Sarah Boone placeholders up like 30-minute before, please? We would so appreciate it on the YouTube streets." Okay. Okay. Please, ma'am, Kathy. All right, let's see what Kathy is talking about over here. Girl, Sarah Boone trial delays. What? Let's see. Earlier, I said I've had weird gut feeling Sarah Boone's trial could, and I don't mean for the state necessarily. It does feel like the defense is behind the proverbial 8 ball. That's from Joel over at Surviving the Survivor. Um, Let me click on latest. We don't need all that old. We covered all that 4 hours ago. This is true crime as entertainment. Sarah Boone will not have her 2 bags of chips candy as Judge Cranick denied her motion to bring more snacks. Hashtag suitcase murder trial. Okay. Hashtag suitcase murder trial. Okay. Um, let's see. The jury of 6 people and 8 alternates has been seated. We know that because you guys saw the video yesterday. If you did not see the video yesterday, I will pin it up top. Um, we might watch that tonight, or I'll provide you guys the links and go give a view. You guys may have already watched it. I don't know. I watched most of it, Mr. Henderson's presentation. I didn't get to see what Mr. J would ask. I am kind of intrigued by Mr. J's voir dire. But we'll see how that goes. All right, let me see what's going on here. Okay. Court TV put up an 8:45 start, but it's 8:49. It has not started yet. He said they were having regular court this morning. I didn't know if that meant the pretrial Richardson hearing, or maybe they just need to clear some things prior to jumping in to court. So it's quite possible that we may not even start at let me hush because girl, let me hold on one second. They just opened, it's looking like they now this is court TV. I don't know what's going on in Law and Crime because they take their damn sweet time about putting that stuff up. Um, we'll just hold on a watch page over here. We'll just girl. Let me do like that. Like this, like that. Okay. Shouts out to our good friend Tabitha Brown. Mr. Darius tried to come for her, and the internet said, "Not it. No, not even not today. Not at all. Sir, stop. Sir, back up and have a seat." Um, it's the live feed at the moment, guys. I'm gonna just reserve for a moment. Let me check. Law and Crime, I don't know. I feel like I'm not trying to pick favorites, but it's whoever's streaming the best feed. It's whoever's streaming the best feed for me. Um, mhm. Where Law and Crime, you really need to put up something because they have so many damn channels, right? And they're all called Law and Crime. I don't see it. I feel like it should be on this one, but I don't see anything yet. Let me just go to live. I guess it'll come up when it does. I feel like I'm about to sneeze. Let me go get a box of tissues and ooh, I got nervous. I was thinking about there's 149 people getting ready to watch me sneeze and it went away. Okay. Okay, guys, give me just a second. I know. Oh god. Let me go grab some tissues. I'll be right back. Okay. Guys, it's like I went to the maintenance cabinet. My pantry closet with all my stuff. Oh, okay. Nice fresh box of tissues for the girl who gets fall allergies. Yay. Um, okay. So what else was there yesterday? There was the and we just got the file with 100 and some odd JPEGs. And why did we get this the night before? And it's unclear what we have this for. So it was the late evidence for the Richardson hearing. And the Richardson hearing, I know someone mentioned um what a Richardson hearing was in the chat. It Richard, excuse me. Uh I know it's because I just came from outside. Richardson hearing. Okay, let me tell you guys. Let's talk about that later. Oh, Richardson hearing, Florida. What is a Richardson hearing? During the discovery phase of a criminal trial, both the state and defense have an obligation to disclose relevant information and relevant evidence to each other. This sharing of information promotes fairness and allows both parties to adequately prepare for trial. If there is a reason to believe that an opposing party has failed to comply with their discovery obligations or has withheld evidence, they can request what is known as a Richardson hearing. The purpose of this hearing is to determine whether there has been a violation of discovery rules and, if so, to determine an appropriate remedy. This page, okay, so let's see. Okay, we're on the medallion. I don't know where. Okay, look at me. Look at the state of Bougie gang. Okay, y'all. We are sitting, no offense to anybody in Florida. You guys know I am a Florida fan. Florida is like deeply embedded in my heart. I love Florida, and I also have a lot of family in Florida. So it's and it's a state that starts with an F, right? It's the only state that starts with an F. So, F's are special to me because you know why. Anyway, okay. I'm going on. So it was the drag, it was the denied, it was the evidence, it was snacks denied, it was the Richardson situation. Um, I don't know what is going on with your folk over at Long Crime. Let's see. Okay, well we're where we need to be. Um and I will position myself right there. We'll be watching from the clouds, okay? What else do we need to talk about? Okay. I feel like that was it for right now. If you're new here, welcome. Welcome, welcome, welcome. And let me see. I usually like to use this one during. Okay, let's see what you guys are talking about. Girl. Oh, what did you guys say? I said I need to send a note over to. I do need to post on Love Lies and Lace Front so they know, like, y'all, I'm over here. I'm over here right now because we have to handle this important court business. Okay. Period. And I'm just kidding. Don't ask me why. I'm very funny about my hoodies. And like, if I have it zipped, I like to have it like, I don't know, especially when it's cold. When it's cold, I need something on my neck. I have two very cold spots. My feet. I don't like my feet to be cold, and I don't like my neck to be cold. I'm not a turtleneck wearer per se, but I don't like my neck to be cold, and I don't like my feet cold. It's cold today. What's the temperature? Oh, it's 43 right now. Yes, absolutely. I just got a bag full of stuff from Savage Fenty. Um Mostly switch like sweat like lounge not so much athleisure, but loungy type. It's athleisure and lounge. It's like, hello, let's cook. Ooh, okay. It's still on the medallion. Wait, hold on a second. I need to get one oh, I need to get one thumbnail that I really, really, really like. Hold on one second. Um, Why did my virtual background stop? Ooh, this is another one I downloaded today, but I was just like, maybe this one's more interesting. I think I like me over here. I don't know what happened with that. Okay, give me just a second. I need to blow my nose. Okay. Um Early morning. Yeah, when she said jumper, I was like, is it jumper or you know how some people say jumper like romper or yeah, oh no, I've got like 12 boxes in the we have a couple of pantry closets. I guess I call it a pantry closet, but pantry I guess typically means food, but um storage closet in the laundry room and it's full. It's got I think I have a dozen boxes of um Kleenex, I have, you know, all of our paper products, girl. Um, yes. I mean, body wash is ridiculous. And soap. Oh my god, toothpaste, we probably have a 2-year supply. I was on Subscribe and Save during Auntie Rona and I don't know, I think I at a certain point I realized we're good. Like I almost have a little store in here. Um, so some stuff I just had to stop getting. Who you just moved to the South? Okay. So when you say jumper, do you mean like a jumpsuit romper type thing, or do you mean a sweater? I have what appears to look like a jumper, what my mom would have called a jumper back in the day, which I think is pretty much called a romper. I think old school people call like rompers or like not so much denim overalls. How did I do that? Um Jumpers. Like for instance, oh, one piece hoodie. Okay. Um, when I was in Catholic school, we had juniors and seniors, we wore a skirt, and freshman sophomore year, we had it was kind of like it had a back to it and it came over and you had your crest. Junior and senior year, we wore skirts with blazers and it had the crest on the blazer. And they called those dresses jumpers, but you had to wear like obviously like an Oxford shirt under it or whatever. Okay. I mean, I've lived in the South since I was 19. I lived in Texas and then I went home for a couple of years and I've been here since I was 25. Um, well, November 94. Okay, 24. Girl, 30 years. Oh my God. I've been in North Carolina for 30 years now. And so pretty much almost my whole life. I'm still a Jersey girl though. And and I lived in Texas for 5. Damn. Okay, Court TV. Oh yeah. I was like, are we still on the Has anyone seen Law and Crime come up yet or they're just not messing with us today? It never gets old seeing Sarah escorted in shackles. I'm sorry. It doesn't get old for me. Maybe when the cameras come up, well, they might show her coming in. Um obviously the jury won't be in and the jury probably won't be in for a little minute because they're going to have to settle the Richardson matter, right? Let's see what's going on here. Okay. Morning. Good morning. They should be interesting. I cannot wait to hear opening arguments. I don't really want to interrupt during the opening arguments. Um, Maybe in between opening arguments. I mean, I might like, ooh, you know what I mean? Like, ooh, like, but I'm not, I just want to listen to every word. You guys give me some more points from yesterday. I guess that it took how many days? It took 4 days to seat a jury. Um, so they came in Monday, they had 2 panels of 50. Tuesday, they had another panel of 50. We had court Tuesday. Did we have court Tuesday afternoon? No. Wednesday afternoon, there was court. Yesterday morning, we had court. They finished up jury selection. So they did a voir dire Wednesday. They did it Thursday. So the voir dire portion was able to be broadcast. Um, and then today we're in court. So I guess that's pretty good. I don't know. I mean, didn't it take months and months and months for Young Thug? So anything over and above that drama, okay. Um, so they seated a jury yesterday. That was good. It took what, 4 days, I guess. Are we getting started? Ooh, y'all. Y'all. Okay. Opening statements. I'm gonna check and see if law and crime, but law and crime, uh, mm-mm. Let's see. Girl, there's already 4,000 plus 4,300. People are scattered all over the place. There's several people streaming right now. Okay. This is exciting. I mean, it's exciting. I feel like I probably heard about this case maybe like 2 years ago. Maybe I heard it in passing whenever it happened, but definitely about 2 years ago, roughly about a year and a half ago, I was looking at my feed, as far as what I've put out about Sarah. It was a year and a half ago, maybe like March of was it March of 20 it was March of 22 or March of 23? So maybe March of 23, I put up my first video, and it's like it's been 2 years, and I feel like when I talked about it back then, it was obviously the trial was supposed to start. She could have been on attorney number 7 at that point, but I can't even hear anything. Let me put my headphones in. I have all my sound running through, so I can't hear anything. Anyway, um, it's not exciting from the standpoint. I mean, she is going to be drugged, but it's like, gosh, this is taking so long. I feel like zipping all the way up, and then sometimes it's so funny when the camera's not on, you can just like do whatever, but it's like, all right, let me just stay like this. Let me not look like a total nerd. Okay. All right, let me get my footrest. Girl, let me get my footrest together. I was thinking this morning, you guys are going to be like, Fran, seriously? Boy, if I could have figured, not so much figure out because I know I can do it. I do have a lap desk. Girl, if I could not fall asleep, I would have been phoning it in from the master bedroom. Okay. I probably need to pivot and go into my actual space, my cloffice, and park on my big ottoman because we'll do that one day next week. Live from the glam room from my cloffice. And yeah, we'll do that next week. That'll be for my court watchers, okay? All of my court watchers. Let me see. You are the one that brought it to my attention. Oh, I brought you the awareness of Sarah Boone. Really? Well, thank you, sis. Thank you. My pleasure. It's my job out here on these YouTube streets to keep all of you informed. Okay, my audience, to keep Bougie Gang aware, provide awareness. Yes, the closet. It's a closet office. It's a full room, but it's set up. It's I wanted when we sold our old house and bought this house, it was very important that I had a YouTube-esque studio. And also, glam room, whatever, why not? We're a small family and we don't need all these bedrooms. And I have a whole rant that I could go on about having bedrooms set up for nobody that lives there. I don't do that. Um, Guests usually go to hotels and or we have a big family room that can accommodate and it's private. Um, but I don't have bedrooms set up for we're using our space. We live here. Anywho, so yeah, it's my glam room slash office, but I camp out here mostly because I'm close to the front door. I got the kitchen close by. I'm 20 feet away from letting the dogs out. It's just better because when I'm in the back, it's harder for me to tend to my dogs and the front door because it never fails when I'm in my office. Um, the mailman, UPS, FedEx, the dogs go crazy. Plus, I don't like them in there. Um, you know, so and Lambo's still, he's still officially a puppy, in my opinion. He'll be one next month. So and you guys know also, I really started doing this too this time last year when little mama was transitioning. RIP to little mama, my almost 17-year-old um, rescue who I had from weeks old. And she was going through it. And I really had to keep an eye on her. So Lambo will be a year in November, but we didn't get him until January. So he's another rescue. But mommy was going through it. And towards the end of her life, she couldn't walk. I don't even want to talk about it. Um, so it was a lot. And I couldn't be all the way in the back because probably like her last week here on earth, she couldn't walk anymore. We laugh about it sometimes from a standpoint of I said, mommy went out like a champ and she wanted to make sure that we remember her forever. Okay. She took us through it in her last 2 weeks, like only she could. And because we loved her so much, you know what I mean? And but yeah, she took us through it. So um it was not a laughing situation, but it fills my heart with joy that I was able to, keep her comfortable and happy and all of the things, until she died the day after Thanksgiving. Um yes, we will. We'll read Lambo's adoption paperwork, which is so hilarious. Lambo was surrendered by somebody who had just gotten out of jail. Maybe you guys don't know this story because I probably told it on Love Lies and Lace Friends. But we brought Lambo home on his paperwork. There was a guy who had been in the county jail. We got him up in Union County. Any of my Charlotte people, we got him at the Monroe Animal Rescue and they basically they had a little write up that basically, do I have it over here? Hold on a second. Y'all are gonna laugh. Okay. I'm not gonna even tell you guys Lambo's name from the shelter. But he's from Union County. This doesn't have my name on it or anything, does it? No. Um He was so male, mixed, short hair, dropped ears, owner surrendered, black and white, tall, small size. Well, he was a puppy, age 0 to 4 months. Owner claims he just got out of jail and found two female dogs and 17 puppies at his residence. I think they are his dogs because he said, I can't do this anymore. That was on 12/28/23, and all of his shot records and stuff. But yeah, owner claims he just got out of jail and found two female mama dogs, and 17 puppies. And we wanted two puppies, but they were like, all the puppies we have right now literally are like from the same two dogs, and we don't know what litters what, and they all might have the same male daddy. Like, okay, they might all have the same daddy. Okay. A cluster mess. Lambo has not disappointed. Lambo gets into everything. He's looking at me right now. But so mommy's ashes are at the fireplace. We have her. I had done last year a promotion for Roses Forever. It just so happened I did it around the time that mommy passed away, right before. So I got one of these heart-shaped plexiglass rose things, and it has a drawer underneath. So cards, some of you guys sent cards and notes and gifts, like dog type memorabilia for me, and I appreciated that so much. And all of that is in the pocket underneath the Roses Forever display. And mommy's urn, it's not an urn, but it's a square with her name engraved on it, is sitting on top of it. It's on the fireplace. Anyway, okay. Just a little sharing. Just a little sharing is caring, right, Bougie Gang? I miss her so much. And I probably love Portia. Like, I love Portia so much because she knew mommy, and mommy pretty much, I don't want to say mommy raised her, but she did. From a dog perspective, mommy showed her the ropes. You know what I mean? I'm so grateful to mommy because had it not, mommy took her outside. Mommy showed her the ropes. When we got mommy, I had to show her everything. Portia was raised by mommy, and I love that she has that mommy in her. But let me tell you something else. Lambo, his coloring, me and my husband talk about it all the time. Like, sometimes Lambo will walk by because his coat is he's black and white. It Sometimes I have like, oh my God, was that mommy? Like, sometimes when he's just in my periphery, um, it gives me mommy vibes. So, yeah. Um, I want to get a chow chow, but everyone tells me how aggy they are. You know what? To your point, it depends on how they're raised, but it also, to me, it depends on how much time you spend. A lot of time with your dog, you love on your dog, you talk to your dog. Talking to your dog really is key. Like, not at him, not just orders, but like, not saying you're going to sit and have a conversation, but you know what I mean? Like, that your dog really kind of understands you because they understand you more than you think. They understand sign language. So if you teach them some commands with your hand, dogs are, it's just a blank canvas. The more you put into your dog and spend time with your pets, your family members, the more pleasant, the more you will enjoy them. But the first year or two, it's not easy. I mean, I'm a seasoned dog person and Lambo has tested my patience. I've threatened him on numerous occasions that he's going back to Monroe, but we're not taking him back to Monroe, but I guess it makes me feel better saying it, but he doesn't understand. He's like, "Huh? Girl, could they please get this? Girl, we are small talking it up, okay? I need to make sure I mark the time so people who come in are not annoyed by our banter. But if you're new here and you want to get to know us, this is, we keep it very cute. Um, and and that's it. That's it. That's all. We talk about whatever the occasion permits. Seems like Sarah is getting they have it looks like the camera is perched, ready for the shackle shuffle. Are we ready for the shackle shuffle on today, guys? If you're ready for the Sarah shackle shuffle for opening, Mr. J is gonna drag. And girl, please God, don't have Mr. Henderson. If Mr. Henderson, who wants to, should I put a poll up? Who are they going to start with Mr. Henderson or are they going to start with Mr. Owens? Who is going to do the opening statement for Miss Boone? Why is Court TV running? Girl, Court TV, stop it. I just looked down. I was like, that's not mine. Okay, now it wants to act up. All right. Okay. I had to check. Okay, law and crime. Oh, that's messed up. People, so I told you Court TV had roughly about 4,300 and people have abandoned ship. Law and crime just opened up and they've got 17 in there. Okay. And it's spinning over there. Is it spinning everywhere? Should we stick with usually we have a better time with Court TV. I mean, Law and Crime. What's it called? Court TV is probably like, damn, Law and Crime came in. We lost like 2,000 people right away. Maybe Court TV heavily moderates their chats. That could be it. That's a bone of contention with most people. They don't want to be censored and maybe Court TV is a little poo poo. Maybe they poo poo too much over there. So I don't know. Let's switch over here. Hey, long crime, what's going on? Did I? Which banner? Okay, this commentary. Yes. Okay. Let me check my monitor real quick. All right, I'm gonna close like a ton of windows right now. Let me close Twitter. I don't wanna miss when the shackle shuffle occurs. Okay. It's like, my god, it's already 9:30. Okay, there he goes. There's the sheriff. He's the one who usually sits off to the side. You know what? Let me drop this stream into Patreon. Okay. She's coming. I wonder if they do like a nice coffee and some cookies or snacks for the jurors. Here we go. Yes. Well, they buy her another suit. She needs a navy girl, does she the wind must have caught her. She needs a navy. They need to just invest in one more suit. Oh, is that a pantsuit? Okay. Oh, yesterday, she didn't want people to know that she's had 9 lawyers. Um, they talked about if Brian Boone is questioned, it could come out that she's been in Orange County because if she wants to bring up the divorce information, that could be a problem. What else came up? I really think she's here for the experience. I really do. I think she doesn't have anything to look forward to when she gets out, and we don't even know if her kid deals with her. It's feeling like before I go to prison, this is my last big hurrah.
William J. for the state.
James Owens on behalf of Sarah Boone.
Tony Henderson, Sarah Boone.
I do.
Ma'am, good morning. Can you please state your full name and date of birth for the record for me?
Sarah Boone, 1010 7-7.
All right. Ms. Boone is seated at counsel's table, wearing a black suit and a pink blouse. She is in custody in this matter. However, there are no restraints that are affixed to her person. So we will be standing when our jury enters and exits. Before we bring in our jury this morning, yesterday the court had reserved on a Richardson hearing regarding Exhibit 2 as identified in the defendant's 5th amended reciprocal discovery exhibit list, specifically 119 pages of records from Advent Health Winter Park that were provided to the state yesterday morning by way of USB drive. Yesterday, the court had ordered that the defense was to provide an edited version of only the records pertaining to anxiety and the lack thereof, or anything pertaining to those matters, but before 9 a.m. this morning. Was that done, Mr. Owens?
Yes.
Okay. Mr. J, have you had the opportunity to review the culled down list of 119 documents?
Yes, sir.
Okay. What is remaining of those 119 specific JPEG images, and what do they pertain to?
Most of them deal with just billings, observations by the medical personnel, so that don't necessarily apply to the issue of anxiety, as the court had indicated. I did include certain pages that discuss depression issues, as I believe that they were related to anxiety, and then I've identified 4 or 5 other pages that are not anxiety related that may be relevant to the case. I've described that.
Of those 119 images, how many are being sought? 15? Okay, thank you. State response.
Apparently, these are all just related to a January 23rd, 2018 admission at Advent Health Winter Park. So it appears they're not seeking to introduce any records from other instances that were contained in the records that were first disclosed to the state on September 27th.
You speak of the 81 pages?
Yes, sir.
Thank you.
Nor the new 119 pictures that's still not in a PDF form. So of the 15 pages, the first 2 that they list are pages 9 and 10 out of 111. And I believe I've identified them as best I can. However, the Bates stamp from the hospital is over other text, and there is no other Bates stamp. So I had to, I'm guessing that it's pages 9 and 10 out of 111. It appears to just be a health information sharing sheet, like a contract. I don't understand the relevance of those 2 pages. Pages 21, and then they skip 22, 23, 24, and 25 are all part of her initial assessment on 123.18. We don't object to those pages, but for, and I apologize that there's a but for, the fact that at the bottom of page 25 begins her toxicology screening, and that does go into page 26, and they did not indicate that they want to use page 26. However, without page 26, we are going to experience relevancy issues and a 403 objection from the state. And that is because in her toxicology screen, for which she is coming to the treatment to seek treatment for depression symptoms, she is at 165 for ethanol, meaning when converted, it's 0.165 grams per deciliter, over twice the legal limit. It's a central nervous system depressant. We are going to have at least 1 medical doctor, well 2, the forensic pathologist will testify for the state, and then our expert on battered spouse syndrome, if we get to that point, is also a medical doctor. She's a psychiatrist, not a psychologist. Will tell us that ethanol is a central nervous system depressant. I believe even the psychologist will be able to get that information in. So we are objecting to pages 21 through 25 coming in without page 26.
If I understand your argument, is it a rule of completeness issue?
Yeah, I mean, in the sense that it applies to documents as opposed to statements. I mean, it is an out-of-court statement, so it is a rule of completeness issue, particularly when the symptoms and the complaints of the patient on that particular day were crying and being depressed and showing signs of using a central nervous system depressant. The rest of the talk screen, pages 27 and 28, they did not list. We are not complaining that they are not including that. Page 29 is another page they listed. That's more of a narrative about her visit at January 23rd, 2018. We do not object. Page 43 is just her vital signs. We don't object. Page 44 is more of the initial assessment on this January 23rd, 2018 visit. We do not object, nor do we object to pages 45, 46, or 47.
What are pages 45, 46, and 47, just for my own?
More of this initial assessment.
Thank you.
I feel like that's not me, but maybe it is.
January 23rd, 2018 was my understanding.
I'm like, oh my God.
Page 48, we are asking again that this be included. Again, I don't believe it's super mysterious why we are going from pages 43, 44, 45, 46, 47, and then skipping page 48, and then going to 49. But we do want page 48 included. On that page includes her height and weight at the time. Page 63.
What's 49? So seemingly that's included.
49 is just some results. Again, it's misleading and doesn't provide full context without what I've described as page 26, because part of the results on page 49 show that she was tested, shows that she was tested for the presence of ethyl alcohol or ethanol, but it doesn't give the results.
Are the results contained in another page?
Just on page 26, the one I previously described as wanting included.
So not following 49 to 50 or 51 sequentially?
No, because the pages they want from the 40s are 43 through 47, skipping 48, and we're asking for 48 to be included between 47 and 49 to make sure it's relevant and complete. And
But they are also seeking 49, correct?
Yes.
Thank you.
Just they just skipped 48, just like they skipped 26.
Okay.
Page 63. It appears to be repetitive, but we don't have any particular objection. Page 63 of the 111. Page 108 seems to be another part of the initial assessment from January 23rd, 2018. So we don't object to that. So basically we're asking for pages 26 and 48 to be included.
Okay, thank you. The defense did, or I'm sorry, the state did seek a Richardson hearing yesterday in this matter, and based on binding precedent by the 6th District Court of Appeal, Young v. State 369 Southern 3rd 1243, regardless of the culling down of the records, the court still is required to conduct a Richardson hearing. As to the issue of whether the defendant's violation was inadvertent or willful, Mr. Owens had advised that these documents were obtained sometime last week. He was unable to provide any specificity. He's going to confer with his office. Mr. Owens or Mr. Beck, are you in a position to advise when these documents were first requested, when they were received, and when they were sent to the state? Specifically, any documents pertaining to Exhibit 2, the Advent Health Winter Park records?
Judge, I did check with my secretary, Margaret, and my understanding is I didn't know that was going to be a question about when we actually sent it out. I know it was one of my trips down here. I got Sarah Boone to sign a medical release. We sent it to the hospital. It took a couple of weeks, I want to say. We got it last week. We don't know exactly when. We don't timestamp at our office when something is mailed in, and it was mailed in from the hospital to my office. For whatever reason, the records did not get to Shelby, who was handling that issue, until late. It was yesterday or the day before that she was aware that they had not been disclosed. We provided the copy to the state at that time.
So did these records come in batches? Because my understanding, based on the state's representation and their objections, was that the first 81 pages came on September 27th. Those were provided.
Those were separate. Those were records that some of the other lawyers, one of the other lawyers had received, and we sent them on, but the problem was they had notes on them. So we sent that 81, but it wasn't directly from the hospital. So we were trying to get a more complete, unedited copy of the records. That's why we made our request.
Okay, and when was the error identified in time as to when these items were not sent, such that they were provided via USB yesterday?
Whatever date we gave them is when we realized there was an error, that same day.
Okay, my understanding that would have been yesterday morning.
Yes.
Okay. Anything else, sir?
If I may real quickly, based on the invoice that was sent from
You can't include it.
Advance Billing Department, as a separate subcontractor, the request would be on 27th of September. I suspect they waited until they received confirmation of payment of $135 for the receipt of those. So we received those. So it's all been within a couple of weeks, but we had a hurricane issue last week, and I think there were issues as to the matter being provided for. I did speak with the state yesterday afternoon after I had a chance to look at the records, and advised the assessors what the matter or relationship to. I was told that they already had those records and familiar with them. So I don't think there's any prejudice to the state based on our submissions.
Okay. Any further argument or positions with regard to the Richardson analysis, Mr. J?
That's for the purpose of this hearing, I'd like this stack of documents.
Is that the 119 pages, sir?
No, sir, it's the 81 pages that we got on September 27th, 2024.
Any objection? All right, what was pre-marked A for the purposes of the Richardson hearing will be received without objection as states 1.
So, they better have everything on point moving forward, I would imagine. I feel like we're like a minute behind. We're like a minute or two behind.
Your Honor, there was just a reference that 81 pages were all marked up by the defense. There's no markings. The issue and the confusion that the state attorney's office still has, though, is page 68 of 81 of these original 81 documents.
If you have a cell phone on, they need to be silenced and turned off, please. If you cannot follow the court's instructions, due to the publicity in this case, I will ask for you to be removed. Does everyone understand? Thank you. You may proceed.
And I realize that I've only had a limited amount of time to review the 119 pages that came in yesterday. And again, it's more difficult to review those because it's not in a PDF where I can word search it and do any of the things that are afforded to us with modern technology. It came in as 119 separate JPEGs. They're not in order. So for instance, when I'm trying to look for page 43 of those 111 records out of the 119 pages, it's not in order. And I've done my absolute best to try and see if this page, which is 68.
Yes. And referring to 68 of the 81 that was
Yes,
entered
sir.
as 1, correct?
Yes, sir.
Thank
It
you.
is sub-labeled within these records as page 2 of 14. And it appears to be a part of her visit on January 23rd, 2018. And in the social history provided, it says alcohol use denies, tobacco use denies, and the other part isn't relevant. And I just haven't been able to find that. And so I'm asking for the leeway to continue to try and search for that particular page out of the 119 so that I may ask that out of the doctrine of completeness and fairness that it be included. I'm just at this point, I've not been able to find anything in the records that says that, and I'm limited in my abilities to cheat with technology and put it, if there's a 119 page PDF and you make it word searchable, you just put in the magic word and it helps the attorney greatly. So that's why there's this confusion, and that's part of why I had to raise this issue. Was just at my first glance of those pages yesterday, I knew that something seemed off compared to what was previously provided.
Okay. Any response?
It has a heading, Your Honor. I'm not familiar with that heading in the documents that I was reviewing. I'll look for it again and I'll provide any
Okay.
information.
I appreciate y'all working together on that. So here's what we're going to do.
If I may,
Yes.
We had told the state that we would bring in a printed copy, not the PDF, this morning. But Federal Express, which is the block away, for whatever reason, the road was being constructed, so they closed. So we were there at 8 o'clock to get the copy to the state we had promised, but we will bring one at lunch to hand to state.
Okay, appreciate it. All right. Any other argument with regard to the Richardson issue?
Nobody wants paper. People want
Anything further,
digital
Mr.
so
Beck?
they can read it
Okay.
faster.
With regard to, let me conclude the Richardson analysis first. All right. Thank you both for your positions and your arguments. The court has, as a matter of law, the court needs to determine whether the defendant's violation was inadvertent or willful. Court finds that based on the positions provided by the defense that the disclosure was inadvertent, but I do find that the violation had some level of substantiality to it. But due to the state's review and the defense compliance with the court's order yesterday as to culling down to the pages that we've identified, the court finds that the violation had a limited ability on the state's ability to prepare for trial due to the lack of objections to the majority of the documents, with the exception of page 48 and 26, which are sought to be included. For those reasons, I find that the prejudicial effect of the substantial disclosure is limited, and I'm not going to order the defense, not going to prohibit the defense from proceeding forward on moving these items into evidence. However, I do want to address the 403 rule of completeness issue with regard to pages, 26 and 49 as, 26 and 48 as sought by the state. No objection, Mr. Beck. All right, thank you. So the state's request is granted. Pages 26 and 48 will be included in any evidentiary documents that are sought to be moved into evidence with regard to this January 23, 2018 incident, as provided in the 119 pages of item 2 of the defendant's fifth amended reciprocal discovery exhibit list. I will not foreclose the state regarding page 68 of the 81 pages. If they were able to find that additional document, we can address any argument at that time as to why that should be included. Anything further, state, before we bring in our jury?
Judge, the defense team has indicated to me that they intend on using demonstrative aids during opening statement. The ones that I have seen include jury instructions that may not be given and may not be given in the way that the court gives, and photographs that could be coming into evidence. I identified at least one that I don't recognize as something they sought to be seeking into evidence, perhaps two. So I believe we should have a discussion about each and every one of those. They should each be marked for the record purposes by letter so that we can refer to them and make a record. I believe it's in the court's discretion, even though I rarely see it exercised in this way in this circuit, to allow the respective parties to refer to actual exhibits during opening statements. I would urge the court not to allow that. They're going to see them soon enough, but particularly with what they are seeking to introduce, given the motion in limine ruling that the court has already issued, that at this point in time, the latest proffer with the defendant's testimony is not amounting to an overt act that will result in a self-defense instruction, that will result in prior instances of violence coming in, that it would be extremely prejudicial, dangerous, and, to use Mr. Cacciatore's analogy, very impossible to put that toothpaste back in the tube if we amplify our opening statements, which may or may not come to fruition when we start talking about these past instances and battered spouse syndrome. It would be greatly amplified if they're actually seeing exhibits of the defendant's past injuries that she's attributing to the decedent. So I'm asking for us to discuss that.
Response before we go through each photo.
Judge, Yeah, the defense is self-defense. Sarah's going to testify that she was defending herself. We believe the court's going to rule we're entitled to put on a case involving self-defense. And under the instruction for justifiable use of non-deadly force and the justifiable use of deadly force,
I'm not discussing the jury instructions at this time.
there are evidence of prior threats, prior events of violence committed under that instruction. Under the self-defense justifiable use.
Here's my concern. Why are we addressing law in opening statement?
Well, I agree with the state attorney. I did pull up a couple of these on the justifiable use of non-deadly force.
That does not answer my question.
I would agree not to use those.
Okay.
The two I'm interested in using and opening is this standard instruction. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering the verdict. You want to read it out?
No, I can see it, sir.
And then the other one is a reasonable doubt is not under possible doubt, speculative, imaginary, or forced doubt is the standard instruction.
What's your position with regard to those two, Mr. J?
Judge's opening statements, we should be discussing what we anticipate to come into the trial, and that's going to be enough of a minefield. It really shouldn't be about the law. We'll both have an opportunity to use the actual jury instructions, which we have not decided upon. We will have the opportunity to use that overhead or any means that we want at the end of the trial during our closings to put up what is actually decided to be the law after the case has been presented. So it's our position that we shouldn't be using demonstrative aids with portions of jury instructions. We're going to have that opportunity to argue how the law applies to the facts at the end, and we will have the correct version. And if the court is following the tendency that I've seen in this circuit recently, we may, in fact, read 3/4 of the jury instructions to them before we even begin our closing remarks. I think it's premature and problematic to be doing that at this time, and it's not the role of opening remarks.
Any other response?
Judge, I've been doing this 35 years. I've had these boards. I've used these boards at opening statements. I don't know how many times. I've said that I would waive introducing the one specific to self-defense. But reasonable doubt is an instruction you gave to the jury when we got started. And then this weighing the evidence is a standard jury instruction that applies in every case.
Are those the standard? Is that the language of the standard instruction?
I have not had the opportunity this morning to pull up the Florida Standard Criminal Jury Instructions off the Supreme Court website due to dealing with motions to eliminate, trying to prepare my opening statement, and doing all the things that I should be doing on the eve of openings. But I did notice that I did not believe the reasonable doubt instruction was complete just from memory. And I know that's not the complete weighing the evidence instruction either. It's an entire page of instructions for each of those.
Can I see the reasonable doubt instruction, please? Well, here's the first problem. That's the wrong instruction. Florida Supreme Court revised 3.7 earlier this year.
Oops.
That is not the appropriate definition of reasonable doubt. It is not what was read to the jury during jury selection. 3.7 now reads,
Sloppy.
proof beyond a reasonable doubt, and it does not mean proof beyond all doubt. A reasonable doubt is not a mere possible, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty
A
if you
mess.
have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there's not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. That does not track the standard jury instruction. For those reasons, I'm not going to allow it.
Judge, I'll have it redone, the arguments.
As long as we're still in the process of working through. The 3.7 instruction speaks for itself. I won't preclude you from using enlargements in closing, but for the purposes of opening, because it doesn't track the 3.7 instruction, I'm not going to allow it.
And this is an excerpt from.
I think he wants to put it up like he's trying to show it to the jury, but he probably needs damn cheat sheet note cards. That's probably not even for the jury. It's probably for him. Why didn't he do like anybody else would who needs a note? Print out some note cards. If you can't remember your argument, put some cards in your pocket, sir. You should have had your script on your computer on a teleprompter. These people, they don't use modern technology. He could have had a teleprompter running in his computer with his work, with his speech.
That seems to be the standard 3.9 instructions, or at least portions of it. Response?
Again, since it's not all of it, it's misleading. It's highlighting something about the law when we're just talking about open remarks.
Well, look at the
opening remarks.
boxes.
6 through 10 are optional. We haven't decided which out of the optional instructions 6 through 10 we're going to use in this case, because we have not heard the evidence yet. So I just think it's inappropriate to be delving into pieces and portions of jury instructions before we get the evidence. What we should be doing is explaining to the jury what we believe the facts are going to show and the inferences that they can draw from them, and argue the law later.
Last bite at the apple, sir.
Judge, they've got to have some guidance to the law. That in many ways, we do it where we give them the law at the very end, and I understand the reason for that, depending on the evidence that comes in, but there's standard instructions that are going to apply throughout. And this is just giving them an idea of what their role is in considering the credibility of witnesses. I think it's appropriate. It's a brief statement of a standard instruction that comes in on every case.
Let me move to the photographs before I address the 3.9 issue.
And I think for the record, we should mark them.
Okay. Do you want them marked? You want them marked by Madam Clerk, correct? Okay, so let's approach with that first photograph, please. Madam Clerk, yes.
When the jury comes in, I'll get us caught up. We're like about a minute behind, but oh. I don't know why this is lagging so much. Oh, she's having to clock them in. I missed that part. Sorry about that. So she's having to enter them in. I know she's like, look, would you sit your ass down, please? Girl, it's baptismal. It's your pre-baptism class is happening right now, okay? Mr. J is not, one thing that they should know right now is that Mr. J is not he's not here for the foolishness, and he is not going to let anything slide. You want to bring him something, you want to try and slide something under the door, it's going to be a Richardson hearing, okay? What did we learn? Yesterday, we learned about a Richardson hearing, okay? Don't play. Mm-mm. Owens, take a seat. The clerk was like, already? You guys got. I'm clocking in exhibits. Y'all haven't even had the opening statement. Why do you have props? I don't know what this lagging. What in the lag? What in the buffering? I mean, if we're not going to miss anything, I might just bump it up so we can get to, because we're 2 minutes behind. It doesn't seem like anything's happening. Sarah, leave Mr. Henderson alone. Oh, a little bit of tea. Mr. Henderson's daughter, I think was the girl in the pinstripe suit yesterday, FYI. He told the audience, he told the jurors that his daughter is helping. And I think she was the one who came in the pinstripe suit.
Next photo.
If you can't hear, Cece seems to be picking it up. He said something about Sarah. Also a picture next to the sliding glass door, something like that. So you hear what he's trying to include?
Thank you. All these exhibits, except for the first one, A, were in Sarah Boone's phone. The state took custody of the phone. The state had the photographs. The state provided the defense in discovery with these photographs. We intend on introducing these photographs. We don't intend on introducing the blow-ups. We intend on introducing the home size pages, photographs, and then using these as the demonstrative aid to show the jury during opening and then closing the injuries that Sarah Boone sustained at the hands of George Floyd.
Any other further argument with regard to the use of those items pre-marked as A through I in opening statement? Mr. Owens,
Yes, Judge, I sent you some cases.
when did you send it, sir?
This morning.
I have not received it.
I think you were already on the bench, so we sent it to the clerk and the jail.
Has the state seen a copy of it?
I'm familiar with the case law. I did receive the email. I'm not sure if it indicated who all was copied on it, a separate one, but I'll check.
This is just these two cases. Been provided Alsaguer v. State, 326 7th 3rd, 656, Florida Supreme Court, 2021. Low v. State, 259 7th 3rd, 23, Florida Supreme Court, 2018. Yes, sir.
Judge, the court has discretion to allow demonstrative aids. If you look at one or both of those, there was a state wanted to introduce a dummy they were using in a homicide case, which the court allowed. Other cases have allowed photographs and demonstrative aids to be used in opening statements. In the Alcaguer case, which is the 2021 case, trial court acted within its discretion in permitting state's use of a map as a demonstrative aid during the guilt phase rebuttal closing argument in a capital murder trial, where evidence visually demonstrated on the map was not without support in the record. That was actually an exhibit that wasn't in the record. The 2018 case, Supreme Court of Florida, again, the trial court acted within its discretion in allowing a demonstrative exhibit. In that case, it was a murder prosecution. Trial court acted within its discretion in allowing the state to use a mannequin in a demonstrative aid in order to show the position of the gun in relation to the victim's body. The mannequin was used to set out the circumstances of the crime and to attempt to establish aggravation. The mannequin was used to demonstrate the location of the gunshot wounds, the angle of the impact against the skin, the incapacitating nature of each gunshot wound, advising of the trajectories were anatomical, not spatial, and had a small degree of error where only was slight difference between the victim's size and the mannequin's dimensions. There was nothing to suggest the mannequin was altered to resemble the victim. Court allowed, again, court's discretion. As you know, we're claiming self-defense, and as part of that instruction, we're entitled to allege prior instances of difficulties and prior acts of violence so that the defendant who asserts self-defense, their state of mind is different from the norm. I think the two instructions would read, Find that Sarah Boone, who because of prior threats or difficulties with George Torres, had reasonable grounds to believe that she was in danger of imminent use of unlawful force at the hands of George Torres. You may consider this fact in determining whether the actions of Sarah Boone are those of a reasonable person. Goes on to say, if you find it at the time of the alleged second-degree murder of Sarah Boone knew that George Torres had committed an act or acts of violence, you may consider that fact to determine whether Sarah Boone reasonably believed it was necessary for her to use violence. We have a good faith belief that the exhibits will be introduced into evidence. They're demonstrative aids to aid the jury in understanding the circumstances surrounding that relationship and the actions that Sarah took and the reasonableness of those actions in light of their history.
Thank you. Any response, State?
Yes, sir.
Yes, sir.
Judge, the standard is, it is your discretion, and you will only be reversed if you abuse your discretion in this regard. The state is urging you just flat out, as a matter of principle, to not allow the parties to go into the exhibits during opening statements. They're going to be seeing the actual exhibits in the very, very near future. I mean, we can do this. We can play the videos. We can show gruesome autopsy photographs on the big screen as well during opening statements, but those things are all coming. So we're just asking you first in general, let's not extend the opening statements in that regard any more than necessary. Now, our specific objections are this. With A, which is beneath everything now, but the bloody ear from the prior incident, I believe that it's from a body-worn camera, and I think he indicated as much. It was not from her phone. If we get to that point where we know that this piece of evidence is coming in, that would be one thing. But right now, the law of the case is they cannot put on any evidence of prior instances of violence, any reputation evidence regarding the victim, or go into battered spouse syndrome in the evidence until self-defense has been established, and that self-defense must be established by the testimony, and in this particular case, it has to come from the defendant, of an overt act taken by the decedent, which resulted in an imminent threat of great bodily harm or death. And we have had that litigation. We have provided the court the most recent testimony regarding the defendant's most recent statements from the two doctors, and it doesn't exist at this time. So it's one thing for the parties to go into things in opening statements that don't end up coming into evidence. And when the defendant does that, well, under King versus State, the state gets to point out, look, they made these promises in opening statements and they didn't come to fruition. So you need to disregard everything that you heard that was going to happen in trial that didn't. But the problem, particularly for the state side, is we don't get to appeal. So if we go through opening statements and we have the jurors not only exposed to our words about things that may or may not be coming into evidence, but exposed to 1,000 words per picture, if a picture is worth 1,000 words, that amplifies the error. And it's an error the state has no remedy to fix. So we're asking for A, which would absolutely come into evidence. If we get this overt act testimony, which has not occurred yet from the defendant, then certainly A would come in some of the other letters. And there's nothing wrong with them blowing it up like that. In fact, the state has it on their exhibit and will be showing it on the screen as well. There's not, a lot of dispute over whether that will come in if we meet that standard of an imminent act or overt threat of an imminent act of danger. B, I'm not sure B was on their list of items that they sought to introduce from the phone. We would argue a picture of her with her dogs on her porch doesn't have any relevance. I don't expect that to be coming into trial, so we're objecting on that separate ground. And then returning back to C, D, E, F, G, H, I. State is all aware of those photographs. We are prepared to introduce them ourselves through the digital evidence. There's no hiding those things. If we meet the threshold for this sort of evidence coming in.
Could you identify those for me? I'm trying to keep notes contemporaneously.
Yes. C.
It was C through I inclusive?
Yes.
Thank you.
B is the only one that is not a photograph of prior violence. It's, I don't know, it wasn't on their list of things that they sought to introduce, and I don't know what the relevance would be of her just sitting there on her porch with her dogs. But A and then C through I, judge, absolutely at the end of the trial, great. Blow them up, use them as much as you want. But in this particular case, with the rulings that the court has already made about this, based on the state's motion in limine, it is very dangerous to allow them to do this when we are not expecting it to be admitted into evidence based on the current state of the defendant's testimony.
Thank you.
Thank you.
Mr. Owens, if you could address Exhibit B, was pre-marked as B.
But Judge, you've already ruled that these things come in and open. Remember that? prior
No, what I
rule?
ruled is that you were able to discuss them, you address them in opening. Photographs are a totally different kitty.
I said nothing about battered spouse syndrome. I said self-defense. These exhibits come in under self-defense. In arguing these, I've said nothing about battered spouse. I'm talking about self-defense.
I understand.
And prior difficulties, prior acts of violence is a standard instruction.
But the overt act requirement remains. I mean, we've reviewed Holland and read it multiple times.
In good faith, with discussions with my client, we believe there's going to be evidence of an overt act. That she was facing imminent threat, and she reacted based on that threat.
Understood. Your response to Exhibit B.
So look at B. Which one's B?
It's her on the back porch with the two dogs.
Judge, not only did he abuse, George Torres abused.
That's not the issue. The issue is that the state represented that it was not part of your exhibit list.
I believe it is a part of the exhibit list. We got this from the state. They sent over a bunch of pictures of flowers or paintings that they want to introduce that they listed as exhibits. I thought for sure we put this on there, but the relevance of it is not only did he abuse Sarah Boone, George Torres, he abused the dogs. And he would threaten to abuse the dogs to control Sarah Boone.
They're trying anything.
Thank you.
Nobody needs to see a picture of Sarah and her dogs.
All right. The court's prepared to rule at this point in time. Thank you both for your presentations and your argument. The court's had the opportunity to what was pre-marked
mess.
A through I inclusive. First, with regard to the portion of the 3.9 instruction, purposes of opening statement is to set the table of what the issues are, what the parties believe the facts and evidence will show. It is not a proper time to be discussing law or elements of law, and that is an element of law that will be instructed to the jury at the end of the case. So the court's going to exercise its discretion for those reasons and prohibit you from using the portion of the 3.9 instruction in opening statement. You could talk about, this is a job that you're going to have, but I'm not going to allow you to read portions of the instruction for those reasons at this time. With regard to what was pre-marked as A through I, the Holland case is clear. Before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. I understand your good faith belief. I take no position on whether or not you're going to make it or not. That's something that you're going to have to establish. But the concern is that the photographs, some of them are graphic in nature. The lacerations, the sutures, the bruising, facial wounds with bleeding may have such a impact such that the toothpaste cannot be pasted back into the tube, assuming that overt act hurdle is not met. The court, again, takes no position on whether or not you're going to be able to meet it because I haven't heard the evidence and testimony. So court's going to exercise its discretion for those reasons. You can talk about it. You can talk about it that she was a victim. You can talk about specific, some incidences may have happened, but I'm not going to allow the photographs at this point in time for those reasons, for your utilization of them in opening statements. Any questions or clarifications with regards to the court's ruling? State.
No, Your Honor.
Defense.
No, sir.
All right. Are we prepared to bring in our jury at this time?
Got two other issues.
They've been waiting for an hour and 20 minutes, Counselor.
We intend to play the 2-minute suitcase video to the jury in opening statement.
What? Is that what that's what they want to do?
Again, I'm asking you to urge your discretion. They're going to hear it in the next 2 days of court. It's within your discretion whether we're going to start using exhibits during opening statement.
What's the other issue, sir?
I need to approach it.
Okay. With regard to the video, I'm not going to allow proposed exhibits to be used in opening statements. It's good for the goose is good for the gander. I'm not going to allow your photographs, I'm not going to allow the state to do anything. You can orally talk about what you believe the evidence and testimony is going to show, but the actual evidence is going to have to be presented here through witnesses or through demonstration and publication after that evidence is admitted. Y'all can approach.
While we approach, can somebody from their team start dismantling?
Please, I would appreciate it. Thank you.
How about Mr. J bring a suitcase, bring out the suitcase and just lay it on the floor? How about that? You know what I'm saying? Like, do you want the suitcase just laid out in front for everybody? Like, okay. Ladies and gentlemen, this item here is usually used for vacations, planning a good time, carrying your clothes. Someone met their final days in this suitcase. This was a chamber of death for someone, Mr. George Torres, who was in relationship with this woman who decided on one day she was going to create a storyline about playing hide and seek when it was really a setup for his ultimate demise. Ma'am was trying to get rid of her boyfriend. And instead of being an adult and asking him to leave, she went ahead and tricked him into a suitcase. Okay. That's my opening statement. I'm just kidding. That's my opening statement. Okay. Oh. Girl, the dogs have wanted to go in and out 50 times, of course. Girl, after they play bingo. Girl, they were playing who can fold themselves into a pretzel, okay?
Any reason why we cannot bring in our jury at this time? State.
No, sir.
Defense.
No, sir.
All right, let's stand and bring in our panel.
Thank you, Jesus. In his holy name. Okay, let's get back our about a minute. Guys, can someone just tell me that if I close every single window, it's going to be okay? And Fran, stop freaking out about not having your windows open and losing all of your tabs. Can someone let me know if I close it, it's going to be all right? Don't. I hate closing my tabs. I like to have stuff readily accessible, but this buffering, it's like buffer. What are you buffering so much
Things or charge
for?
involved in this case, and then you have not conducted any independent investigation regarding those items. You just raise your hands to confer that you complied with the court's instructions. All right, the record will reflect that all jurors have raised their hands. Members of the jury, yesterday I told you that you may happen to see the lawyers in the courtroom or in the courthouse going about their affairs. And again, they're not trying to avoid you or speak to you because they're not allowed to. Did anyone happen to ride an elevator this morning with any of the attorneys, either for the state or for the
I'm closing stuff now.
defense? All right, juror in seat number 3 from my left, first row. Yes, ma'am. Okay, thank you. Can you all approach for a moment?
Did y'all talk? Were y'all running your yappers in the elevator?
And a juror in seat 4, left to right, first row. Yes, sir. Who did you ride the elevator with? Do you recall who specifically, sir? Mr. Owens. Okay, thank you.
Hopefully they were not running their yappers, didn't see the pictures, see the boards, any of those things. Oh, I'm not in control of when YouTube shows the commercials. It just they do their own thing. I bet you it was the defense. Oh, really? They should have a different elevator. They should have a separate entrance for juries and give them their own
All right,
elevator.
thank you both for your honesty. I appreciate that. Something we talked about earlier this week. That's the one thing that we required and asked of you, is just be open and honest. And I appreciate both y'all's open and honesty. During the ride in the elevator, was there anything that you saw or observed that would impacted you or influenced you in any way to have any impact on you? Juror number 3, left to right, first row. Juror number 4, left to right, first row. Okay, thank you. All right, with that, members of the jury, we're going to proceed with opening statements this morning. Both the state and the defense will have the opportunity to present them. I ask that you listen closely to those statements that they're going to provide. But remember, these are not evidence. This is just the party's belief as to what the facts and the evidence will show in this case. After the conclusion of the opening statements, we'll begin with the state's case in chief through witnesses. With that, Mr. J, you may proceed, sir.
Thank you. Ladies and gentlemen, what the evidence in this case is going to show you is that this defendant zipped Jorge Torres shot in a suitcase. She was able to do this because at the time of his death, he only weighed 103 pounds. And she did this with the malicious intent to punish him. And then she went up to sleep and left him to take his final breaths on this earth alone. How many breaths those were, we don't know. The evidence is going to show that it was at least for about 15 minutes, because there's going to be 2 videos that the defendant herself took of this event. The evidence is going to show George Torres is dead because in this defendant's judgment, he deserved it. And out of a conscious disregard for whether he lived or died, you will see and hear these videos. What I expect you will hear from a video that began at 11:12 p.m., 45 seconds.
Thank you, Jesus.
On February 23rd, 2020, in Orange County, Florida, is a suitcase on the ground, face down, with the zippers facing the floor. You will hear Sarah. The defendant will say, "For everything you've done to me." Sarah, "For everything you've done to me." Sarah, "Fuck you." And then the defendant laughs. Sarah, "Fuck you." And the defendant laughs. Sarah, "Stupid." Sarah, "That's my name. Don't wear it out." Sarah, "I can't fucking breathe, baby. Seriously." "Yeah, that's what you do when you choke me." Sarah, Sarah, Sarah. The defendant laughs again. Sarah, "I can't breathe, babe." She laughs again. "That's on you." Sarah, "I can't breathe." She laughs again. Unintelligible words. And I would submit, the evidence is going to show because of the intoxication from alcohol is the next thing she says. Sarah, 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 I can't breathe, baby. That's what I feel like when you cheat on me. Sarah, fuck you. I can't fucking breathe, Sarah. You should probably shut the fuck up. Sarah, shh, is the last thing you will hear the defendant say to Mr. Torres as he is face down, zipped shut in a suitcase. That, again, began at 11:12:45 and lasts just over 2 minutes. At 11:23 and 3 seconds p.m., there's a second 22-second video, and it's the defendant zooming in on the suitcase. And all you hear during this 22 seconds, after he's been in this suitcase since at least 11:12 p.m., is one more time, Sarah. How did we get to this point where 103-pound George Torres is put into this suitcase left to die? Well, the next morning, the defendant wakes up, late morning, perhaps early afternoon, somewhere in this time range, several hours later. And she goes downstairs, and she doesn't see George anywhere, Torres, and eventually realizes, oh my God, he's in the suitcase. The first thing she does after taking him out, and I believe you will hear a description by the defendant saying, took his little legs out. At some point she makes that statement. And tries to resuscitate him. Here's gurgling as she presses down on his 103-pound chest, forcing whatever air was trapped in there out, gurgling. And the next thing she does is she doesn't call 911. She calls Brian Boone. Who's Brian Boone? Brian Boone is her ex-husband. They share a child in common. And this date, February 24th, 2020, is a Monday. A normal work day for most people. School day for their child that they share in common. But after they got divorced, the arrangement was every other weekend, no co-parent. And that weekend included Friday, Saturday, Sunday. So it's that free schedule. And then Monday through Tuesdays, their child would be her responsibility. And Wednesdays and Thursdays, their child would be Mr. Brian Boone's responsibility. So February 23rd, 2020 was a Sunday. And now he's led into Monday, 2020. Mr. Boone had been trying actually to contact the defendant several times that morning because he just wanted to confirm she was going to get their child after school that day. And there had been a history of reliability issues on that issue on her part. So you will see in the phone record, he calls her, then she finally calls him back instead of calling 911. And being the nice co-parent that he is, he comes over. It's a short drive, like 10 minutes. And as she's explaining to him what the heck is going on, he peeks in through the front door of her townhouse, which allows you a view all the way to the back sliding glass door. You're going to see that her kitchen is off to the right. There's a doorway that you can see all the way through. And on the back side of the kitchen and the breakfast room area, there's tables and stuff. There's also some blue legs sticking out in view. Brian Boone says, check please. You need to call 911. He doesn't set foot into that townhouse. He does wait outside though, being the co-parent that he has. So now, after having
first called her ex-husband after having first waited for Brian Boone to come over. The defendant makes the 911 call.
What you will not hear are tears. What you will not hear is sorrow. You will hear a certain level of concern. My boyfriend and I were playing last night. Put him in a suitcase, and we were playing hide and seek kind of thing. I fell asleep. Found him dead in the suitcase this morning. I don't know what happened. He had blood coming out of his mouth. Don't know if it was an aneurysm. Pulled him out of the suitcase, tried to give him CPR. He was in the suitcase and I fell asleep. He's not awake, he's purple, he's not breathing. There's some instructions about how to do CPR given to her, asking about whether an AED is available to shock his heart. It's too late. He's cold, he's stiff, he's purple. We were playing hide and seek. We were playing hide and seek. This is horrible. This is horrific what happened. Like, what happened? We were playing hide and seek last night and I fell asleep. So she mentions that there was blood coming out of his mouth.
And his body, like all bodies in suspicious deaths, was taken to the 9th District Medical Examiner's office in autopsy. What the doctor found was what you would expect after being left in the suitcase, crumpled up in the fetal position. He passed from positional asphyxiation, meaning like you're not going to get full breaths when you're crumpled up like an accordion, and environmental suffocation. You don't have to have a plastic bag over your head, tape shut with a full roll of duct tape to seal it off 100%, be worthy of the vacuum of space to environmentally suffocate. It's close enough if you can't get the oxygen and the CO2 coming in and out of your environment. But she also did notice, yeah, he suffered from blunt force trauma on his torso, in his face, his mouth. She'll use words like contusion. Will help her explain contusions and bruises. She'll use words like hematomas. Will help her understand for you all that that means bleeding under the skin and blood, what you expect to improve. That's why they're running through. But he had all this additional trauma. He had trauma on his fingers as well. So now, the sheriff's office. Orange County Fire Rescue show up. When the defendant interacts with the first patrol officer, you will see and hear that body-worn camera. It's more of the same of what we heard on the 911 call. Hide and seek. It was good. I fell asleep. I don't know what happened. A few hours later, the detectives from the homicide unit of the Orange County Sheriff's Office approach her and are ready to interview her after doing some initial things, which includes grabbing her cell phone off of a counter that was found at a suitcase by Mr. Torres, and giving it to one of their digital forensic examiners, who we'll hear from later in the trial from now on. But it's time to give a first interview with the defendant. So they do a first interview with the defendant in one of their
Unmarked detective patrol cars there on the scene. And the basics of this remain the same, but there's a little more elaboration, as you would expect from trained detectives versus getting the 911 call taken. But the basics of what the defendant tells them is we had wine, we painted, we drew, we did puzzles. The particular wine we had was a Chardonnay from the Woodbridge winery. The bottles, plural, are in the trash. We started about 4 p.m. after Mr. Torres went to the store. Puzzles, art, listening to music, enjoying each other's company. We were literally just enjoying one another's company. The other bottle of wine that was left over from Boone wasn't even half full. So the description she is saying is one bottle of wine and plus a fraction of a bottle of wine left over from the night before. Ladies and gentlemen, not all bottles of wine are made the same. Many of us may envision what you would expect of a restaurant. Those are 750s, 750 milliliters of that. Bottles of wine that were recovered from the defendant's trash can were 1.5 liters, so the equivalent of 2 standard bottles of wine. A 1.5 liter bottle of wine is 50 ounces. Given that a standard serving of wine is 5 ounces, you can begin to do the math. And there's receipts. The day before, Saturday, February 22nd, 2020, there is a receipt.
Did he say there's receipts?
For a bottle of Woodbridge wine for $9.74. And then Sunday at 12:17 p.m., there is another receipt for $9.74 for a Woodbridge Chardonnay bottle of wine. And then at about 5:30 in the afternoon on February 23rd, again, there is another receipt for the same bottle of wine for the same price. And those 2 bottles of wine were recovered. They're going to be produced to you in evidence, and you will see that they are in fact Magnum bottles of wine. So that's the context that we're dealing with when we hear things like, we only had 1 bottle of wine and we finished what was left in the bottle of wine from before. Well, ladies and gentlemen, there's 2 1.5 liters that apparently were consumed by a 103-pound man and the defendant, who is in the same weight class. Plus, if you believe that the defendant and the decedent would leave leftover wine from any given day, any additional wine that was remaining from the 1.5 liters from Saturday. Ladies and gentlemen, that's a lot of wine. So in that context, we were just having wine, enjoying each other's company. At one point, we play hide and seek. She says she didn't zip it up all the way. There was enough room, in her words again, there was enough room for his little fingers to get out. We were still having a good time and whatever. And basically, you know, Mr. Torres is stressing out about jobs, his ex-wife, about money. And so they're just doing puzzles and doing things to keep his mind off of it. Doing art, playing with the dogs, dancing with the dogs, playing hide and seek. We were always trying to outdo each other where we could find each other the best. When they started playing hide and seek, she went up to the shower and then got tired of hanging out in the shower and came down, and that's when she found him playing around in the suitcase. We both thought it was funny. I'm going to zip you up. 2 little fingers could stick out. And she went upstairs thinking, he'll get out, we're going to have sex and go to sleep and call it a day. It was a good day. She insists that they had wine, but we're not drunk. You will be able to assess that for yourselves when you hear the recording she made. No ill will between us last night. Last argument, maybe last week. Don't really argue. We came home, drink, smoke, did art, listen to music, play with the dogs. We drink what we can afford. We used to be able to afford liquor, but now we can only afford wine. And that's how that day ends with the police. She goes and sleeps and stays at her ex-husband's house the night of February 24th and 25th. What they are doing, and by they I mean the Orange County Sheriff's Office, in part, is going to her phone. That's when they discovered the 2 videos that I just described for you. And there's other things in the phone, which I will discuss with you in a little bit. But she's summoned in for another interview, and she sits down and gives another interview on February 25th, now Tuesday. She does describe past instances of violence. You're going to hear about that. She's going to say, Mr. Torres had hit her with a curtain rod about a month ago. Since then, though, like, we've been good. I've been good. She describes that he comes at her all the time. He comes at me. So it's either I flee or I try to go upstairs and go to sleep. That's usually what it is. I don't know if you talk to Brian, her husband, about any of that, but most of the time I flee and I go over there. There's a discussion about why she stays with him, and you'll hear that for yourself. She will say that she doesn't really want to drink. She just takes an occasional drink. She drinks to placate him, Mr. Torres. She says that you're going to see phone videos of Mr. Torres smashing her TV in the past, like a month earlier. You may see that too. But she doesn't get drunk. When she drinks, she likes being non-compos mentis, her words, not mine, having her wits about herself. Then she gets to the hide and seek again and describes that they've played it 3 times before, but had never zipped one another shut in it before. And they were really just running out of places to hide because it's just a townhome. She does not remember, according to her, she does not remember taking any photos or videos of the night's events. At this point, they ask her, well, would you like to see it? And she says, I can't watch this. I flipped him over. I flipped him over, and that's where it was. Guys, this is killing me right now. That's why I flipped it over between the 2 videos. I didn't do anything intentional. Discussion over whether he had enough room to get any of his fingers out from the zipper. My intention was not to leave him there. We both got in there. Both of us were in there. When she went upstairs, my plan was not to, quote, he'll be up here any minute. My plan wasn't to leave him in the suitcase. Why is all this going on? It's the drinking. That's what it is. It's the drinking. I thought he was okay. Guys, that's how we were with each other. Nobody understands our relationship. This whole suitcase thing never happened before, though she described it happening before. I'll never drink alcohol again. She insists that she has no injuries on her, and you don't have to take her word for it because they took photographs of her and there were no injuries on her. She insists over and over that there was no violence that day. It's like, okay, we're in a good place right now. Ask her about saying fuck you to Mr. Torres. Well, that's just being playful and having a good day. Everybody's having a good day. I didn't touch him, nor did he touch me. Her words. What else is found on her phone? There's a conversation between Mr. Torres's brother, and again, nobody knows who's using these phones at the time text messages are sent in these records that you're going to see. But it's indicated that there's a communication between one of the decedent's brothers and the owner of the phone that was taken that belongs to Miss Boone. The text from the brother is, yo, my daughter told me what you did, Sarah. I don't want you around any of my daughters or nieces, nephews. And that's Christmas 2019, just under 2 months before this event. She replies, or the person using her device at this time, ugh, your quote unquote dad hit me in the face. The next text is, hide and seek, I shall. January 13th, there's another heated discussion. She describes it on January 13th in a text to Mo, the brother again. It's a Torres thing. Boo. Sends a picture. Keep the fugly creep out too. It's still fugly. Lose. The brother responds, "Please do something with yourself, Sarah. God bless you." The defendant's response, "And bless you and all of you too. I'll get," in all capitals, "rid of him. Then it'll be," in all capitals, "better. Ugh, Torres," referring to Mr. Torres, getting rid of. And that's the case. That's what the evidence is going to show. But we, the state of Florida, and the members of the jury in our journey through this case, we're all going to come up to a door that says, "Danger, keep out, stay away, by court order." And that door says, "The defendant's history with the victim is a door we shall not enter without permission and invitation. Halloween in like 13 days. Part of the vampire lore is vampires can't come get you in your house. Well, I participate during this trial. We're going to be invited in to the defendant's past relationship for the previous couple of years. And as we come inside this room, at her beckoning, we are going to have things pointed out that she would like us to focus on. And you're going to hear the first night the defendant met the decedent, Mr. Torres, he smashes her phone, punches her. It's the first time in her life she'd ever been punched. I expect that's going to be. And he made her curl up in a fetal position on her own porch for 4 hours, and she was only able to escape this situation when he fell asleep. I expect that you're going to hear that Mr. Torres is an alcoholic. I expect you may hear his high score on his blood alcohol level was a 342 once when he got treated at the hospital. This is a man who has serious alcohol problems, and I expect you're going to hear about that. Despite that first date, and this is going to tie into some other things that I expect could possibly come in. Despite that first date, despite at that point in time of this first date not having a relationship, emotional ties, and the things that come along with a relationship that make it harder to break off a relationship, it's one thing to have a bad first date, it's another thing to end a 25-year marriage. Despite that first date, there's a second and a third. Now, these days are at bars, and there's nothing wrong with that. But, and it just typically ends up, she's going to tell you, I suspect, or you're going to hear that she said, one way or another. It's one thing or the other. Like, I ask a dude for a cigarette, Mr. Torres flips out, and I'm going to pay the price. Just things like that. You're going to hear and potentially see, yes, there were injuries that the defendant is going to attribute to the victim causing her. Black eyes, cuts in the face, perhaps from the curtain rod incident that was mentioned in the police interview happened about a month ago. Bloody ear, a stab wound in the leg,
Now, like a home inspector, there are experts to come in and kind of help walk everybody through this room labeled the defendant and the victim's past relationship. I suspect there's a chance you may hear from some experts, psychologists and psychiatrists, about battered spouse syndrome. The state is not challenging in any way that battered spouse syndrome exists. It's well recognized. The experts will tell you all about it. Not disputing that at all. But there's some things that we would hope that you pay attention to during all the testimony, if there is any, about this subject matter. One is that it's not actually a recognized diagnosis in the Bible that they use in mental health called DSM-5-ER. Diagnostic Statistical Manual, version 5, and I think it's text revision or something like that. What it is, and what they describe it as, is kind of a component of post-traumatic stress disorder, PTSD. But because it's not actually in the book, it's like a recipe book. It's like our statute books for lawyers. You go into this book and say you have a particular disorder or diagnosis. It'll say, well, all of us agree that it needs these three elements, like elements of crime. Some of these elements have to be prevalent for a certain amount of time, so on and so forth. You imagine it's a cookbook. Gives you the recipe for a diagnosis. But because it's not in the cookbook, you may get some disagreement about what it means between experts. It's kind of like grandma's recipe handed down from generation to generation without being right. But what I special here is, it's important for people who don't have experience in certain abusive relationships that are violent to understand the control that can be exerted over an intimate partner by the other one, isolation, psychological violence, emotional violence, physical violence, sexual violence, which I suspect will be described for you as well by the defendant, perpetrated on her by the deceiver. You will hear about all this. And what it ties into at the end of the day, after we talked about this during jury selection, is if there is a self-defense instruction read to you, this is to help you understand what an objective and reasonable person in the circumstances would do. Because years ago, we've gotten better as a society, but years ago when this was first being researched, the question would be, well, why wouldn't you leave? And battered spouse syndrome, the testimony from these experts help explain those things to people. Well, it's not that easy. You got to look at what's going on in the relationship, the isolation, control, so on and so forth. And that explains why you wouldn't leave. Well, now, but turning to the facts of our case, what you're going to decide the facts are is ordinary, objective, reasonable person in those circumstances taking those actions if you get a self-defense instruction as part of that. That's what it's used for. It's not used for explaining the subjective beliefs that one holds. What you will also hear about these things is, just like any other doctor or any expert, with a home inspector. If a home inspector's report was based solely on the person who's trying to sell the house, what they say about the house, great shape. I rewired the entire thing. Brand new JDC pipes. This sucker's good to go. I'm great at this. You're not going to take that home inspector's report unless they lift the hood, kick the tires, do all the things that the box on here, the Carfax does. You want an expert to get reliable information. An expert's opinion is only as good as the information that he or she relies on. They will say, yeah, you gotta take into account the credibility of the person who's giving you the story, even if it's the patient or the client that is saying all these things have to be confirmed. You gotta find proper information. You gotta check reliability, particularly in circumstances that we discussed. just their day and they get over it. They live their life and find another day. Their cycle spins like that. So just because you hear about those things, what the experts will tell you, doesn't mean that it necessarily applies. If this testimony comes in, I expect that Dr. Harper will say that it applies to the school. But we'll talk to her about what she relied upon to make that conclusion. We'll talk to her about some other things and take that journey together. But at the end of the day, after you hear all of the evidence in this case, particularly straight from the horse's mouth to the video, where you don't have to rely upon the credibility of anything other than your own two eyes and your own two ears, the state admits that you're going to return a guilty verdict for second-degree murder. What the evidence is going to show is that the defendant killed Mr. Torres because she decided he deserved it. Not because the evidence will show an objective, reasonable person in her circumstances needed. Thank you.
Thank you, Mr. J. Any opening remarks by the defense?
Judge, can we invoke the rule? It has been.
I've already advised the witnesses.
Okay, the rule of sequestration will be invoked. Thank you. You may proceed, sir.
Ladies and gentlemen, good morning. Appreciate y'all being here. I was introduced before. My name is James Owens, and I represent Sarah Boone, along with Cole Peterson and Kevin Beck. Now, this is going to be a several day long. Obviously, today, Tuesday, Wednesday, we're not sure.
I mean, Cece can't even hear him. It's like, sir, please. Can you go back to the podium?
I know your focus is on this case because you took it. Ladies and gentlemen, there's no.
I wonder if we email Miss Barrios, the judicial assistant. Hey, do you know that this is being broadcast all over the world and we can't hear? It's like, what do you think he's saying? It's like, can't hear.
Between Sarah Boone and George Torres.
Okay, law and crime, amplify the volume.
Sarah
Thank you.
Boone and George Torres were down and out, as you can be. Their life centered around alcohol. Both of them suffered from, used to be called alcoholism, now it's called alcohol abuse syndrome. And so day to day, they struggle with the use of alcohol. You can imagine that. It affected their jobs. It affected keeping employment. It affected even getting a job. As codependent as you can be towards each other. And you're going to learn with all that was domestic violence. And that George Torres physically abused Sarah Boone. And she suffered from the effects, the psychological effects that one suffers from repeat violence from an intimate partner. They were together over 3 years, and there were several prior incidences of violence. We've got the photographs. There were incidences where police were called who took photographs. So you're going to be able to see the evidence. And we believe the court will instruct you at the end when you're considering self-defense, which we call justifiable use of non-deadly force or justifiable use of deadly force, that you can consider the prior acts, the history of violence, the prior difficulties that the parties had. In considering her set of circumstances that she was faced with in making the decision to use reasonable force under the circumstances. And the most important thing I can tell you here today is keep an open mind. There's two sides to every story. You're going to hear the state's side in attempting to paint her a certain way, as they've done here today in opening statement. And then you're going to hear another side. And you're going to have to weigh that. All the evidence, the credibility of the witnesses, the photographs, the videotapes, and come to a conclusion. Now let's talk about this day, February 23rd of 2020, the date of this event. This case has been pending for some time. Here we are, October of 2024. I think the evidence is going to show that they had purchased some wine the day before, but they hadn't finished all of that. So it was in the refrigerator. Many times that's how they start their day. At some point, you're going to see a video from Publix, from where they live. I believe it's one park. But Publix was not too far from their apartment complex. And they took their car, they drove over there. So you're going to see a videotape from Publix of them both going in the store about noon, and they come out with one of those larger bottles of the wine. And then, of course, there's a receipt, and the bottles are in the garbage can. Of course, there obviously is an attraction between the two. And as everybody knows, couples can have great times where things click, everybody gets along, and then we can have episodes of disagreement. And how are those resolved? Really, that's what this is about. How are disagreements resolved? But George was very jealous of Sarah. And you're going to hear the testimony about that. And that he cannot, in certain situations, he can be very charming. But when his level of intoxication gets to a certain level, is when he gets sad, moody, and a lot of times eventually it involved forcible sex with Sarah Boone or actual physical violence against her. They bought the wine. It's a simple life. They don't have much money, but they both like art. They did that for a while. They both like puzzles. They did that for a while. Well, about 5 or so, the wine bottle was gone. And George had said, I want to go get some cigarettes. So there's a convenience store right close by their apartment complex. And Sarah thought he was just going to walk over there and get cigarettes and come back. But no, what he did was he got her keys, he got her debit card, and he went over to the Publix and he got another bottle. And I think that was about 5:30, something like that. And again, there'll be the Publix video showing him going in, going out, and there'll be a receipt for the purchase of that bottle, and then they'll keep that bottle. Will be in his garbage can along with the other bottle. Well, when he comes in with the second bottle, Sarah knows. This is not good. She knows this means he's going to get to another level of intoxication. So Sarah's concerned. So she attempts to placate him, keep him busy, keep him in a good mood. They drink that bottle, or she drinks as well. And at some point, they're intoxicated at a high level. As some people do, when they're drunk, they get silly. And they decide to play a game of hide and seek. She goes upstairs, their bedroom's upstairs, to the shower and waits for a period of time. And he doesn't come to her. At some point, she gets cold, she gets tired. She wants to go see, well, maybe we got it mixed up. Where is he? So she goes downstairs, and they had gotten a suitcase down a week or so ago. It's an old suitcase that they were going to donate to Helping Hands or Goodwill or somebody, and they were putting some items in there. And it's a broken down suitcase. It's a large suitcase. They both weigh about 100 pounds. And they don't eat good. Malnourished to a large degree. But the pull handle is broken off. And they've attached a little paper clip that's got the rubber around it. And that's how they move it back and forth. Well, she comes down the steps, she sees him getting in and settling in the suitcase. So she walks over there, and they see each other, they smile and laugh, and she zips him up. And she zips him up, and they laugh for a while. And they carry on. She sits on the couch, and at some point he says, "I can't breathe." Now, his face is facing the zipper, and she's got 2 or 3 inches that she's open.
Okay, just real quick. I did email Miss Barrios. I'm sure you're not going to be able to see it because I got the green screen on. You'll just have to trust me. Oh no, that's not the right one. My bad. Hold on. What did I just do with that note? Did not send. Okay, let's get back. I'll show you the note. Oh, it's in my outbox. It didn't go yet. It didn't go. Just a second. Let me send it.
And she doesn't know. They're intoxicated. She doesn't know whether he just saying that to try to get her to get him out or what. But he's a captive audience. Physically, they're the same size, but he's much stronger than her. If they got in a fist fight, he would win 100 times out of 100. But she's got him now. He claims he can't get out. He has to sit and listen. It's a unique form of physical restraint. And so she lets him have it. Says things she shouldn't say. You'll see the video. It's about 2 minutes long. She videotapes it. She sits on the couch and turns her phone on and videotapes it for about 2 minutes. There's another video that's approximately 11 minutes later. The first video, George is, the suitcase is flipped upside down. The zippers are off. 11 minutes later, Sarah has flipped it right side up. Again, open for him to get out. And it's only 22 seconds. And you hear George say, "Sarah." And that's it. Now, the key to the case is that 11 minutes. and what happened during that 11 minutes. Okay? That is the key to this case. Sarah Boone will take the stand. She will explain what happened.
They're laying the groundwork of the alcohol abuse. And I think they're trying to lay the groundwork. George is not a great guy. George wasn't a great boyfriend, whatever. Um, and they're gonna have to introduce battered to be able to go there. So no, they're not. We just have to wait for this thing to play out. So as soon as there's some testimony or evidence introduced that there was some sort of overt act, they can't they have to introduce the overt act.
She will explain why it happened. The evidence will show that she was justified in the action she took to prevent an attack from George Torres, which the law acknowledges that every one of us has a right to invoke, the right of self-defense.
Say this really quick since I'm interrupting. So yeah, I said, "Hello, Miss Barrios. Happy Friday. I'm watching the live feed of Florida versus Boone. Please, for the people around the world witnessing the due process of Sarah Boone, is it at all possible to have the parties use the microphones or have clip-on mics? Thank you in advance. Francoise, entertainment blogger. Real Talk Bougie. I don't know if it's gonna help, but we did what we could. Okay, we tried. All right, we tried.
You can hear from the medical examiner. She is going to tell you about some bruising on George Torres. Of course, he was in the suitcase a while, deceased, we believe. And that changes things a little bit, as the medical examiner will explain, but there's some bruising. Sarah's going to explain that to you, why that happened, what were the circumstances surrounding that, involving the bat. Her son comes and stays with him from time to time. He has his own room. He has several of his things there, and there's a bat downstairs. The same bat that George Torres used, and there's a video where George is threatening Sarah. And he's swinging the bat at the TV about as hard as he can. And he does it about 6 or 7 times. You'll see it. Sarah's recording it. And it's during an argument. And he's trying to intimidate. Sarah loves you. You know, you're going to hear why women don't leave. Why women don't leave. And you're going to hear about Sarah Boone and her struggles, her mental health struggles. Sarah had no intent to kill. Prosecutor mentioned she wanted him to die. Farthest from the truth, she loved the man. She hated the abuse. She couldn't read him. She tried. She tried kicking him out 6 or 7 times. He kept coming back. She changed the locks. He kept coming back. She didn't have the family. She didn't have the support. She was weak, vulnerable. You're going to hear it all. You got to take that all into account to try to understand what happened and the circumstances surrounding this tumultuous relationship. Now you're going to find that Sarah's not perfect. And you know, she goes, as many of us do when we drink too much, you know, you sleep in. She slept in. 11, 12, 1, somewhere around there. She moseys downstairs looking for George. She thought he was on the computer looking for a job. She looked outside, maybe he's out smoking a cigarette, and she sees the suitcase. She unzips it. She gets him out. He's purple. She tries her best to do some CPR. She freaks out. The only family she's got is her ex-husband, really. She relies on him. As the prosecutor said, a lot of times she'll flee to her ex-husband's house. And where her son is at? Lucas. It's the only thing she knows to do. She was kind of a sheltered daughter when she was younger. She's smart, but she's not worldly. She calls Brian. What do I do? He said, I'm coming over. Please come over. He's about 5 minutes away. And she calls him again within a couple of minutes. Yeah, I'm on the way. He gets there. He walks in the foyer and sees his legs. And she called 911. She calls 911 within a minute or two. Detective Rodriguez arrives. You know, they got the body cam now, so it's recorded. So you're going to hear Sarah talking. But Sarah's freaking out.
He says she's not worldly.
And I'm somehow responsible. Eventually, she gives a statement to law enforcement. She gives one to Detective or Deputy Rodriguez. Of course, she's not the homicide investigator. She's just responding. She's the first responder. And, you know, they know what to do. They try to assess the situation. They start putting the tape out, and then they call for the homicide investigators to come, which takes a little time. So she gets a statement from Sarah. Eventually, the homicide detectives get a statement from Sarah. and one of the unmarked squad cars, and it's recorded. You may hear that. And then the next day, they take Sarah's phone. Sarah gives them the phone, signs the consent, take the phone, take it to, they have a phone extraction people at the sheriff's department where they can take it and take out all the data, all your phone calls, text messages, photographs, videos, all that. And they find these two videos. Sarah's not aware, she doesn't remember making the video. You can imagine. She gives them the phone. Well, she makes no attempts to do anything other than, here's the phone. So they tell her, you're going to get your phone back tomorrow. We'll bring it back to you tomorrow. Well, they end up having a conversation with the female detective, homicide detective, Hobson is her name, Chelsea Hobson. And they end up, Deputy Cops was pregnant, or Detective Cops was pregnant. So they end up, hey, we're not going to bring your phone. I'm not feeling good. Pregnant. Can you come to the sheriff's department? Which Sarah Boone was telling you that was what I was going. That's what they told me I was going to the sheriff's department for. Well, instead it was an interrogation, and they were going to arrest her. They made their mind up already, and they were going to confront her and try to get her to confess based on the two videos. And so there's approximately a 2-hour interrogation that was on the 25th in the afternoon. When she got there to get her phone, they said, well, we got to come up here. We need to talk to you. And they got her in the room. It's a small room, but it's being videotaped and audio taped. And it goes on for about 2 hours of them trying to get a confession to murder. And it doesn't happen. But Sarah lies. She's scared. She can tell they're trying to pin her on this, that this was some kind of intentional act, and it was not. So she lied. She's not a lawyer. She doesn't know about self-defense. She doesn't understand she has a lawful right to defend herself. She doesn't understand that she's justified in using the force that she used. She doesn't.
Let me just say, but she understood how to lie. She's not worldly, but she understood how to lie. Okay. Okay. I'm sorry. Let me go.
I wasn't there to advise her. No lawyer was there. So she lied. And you're going to hear that. So you're going to have to balance that versus her taking the stand and testifying before you. And we simply ask that you look for the evidence of cooperation of her testimony. It's going to be later, probably next week. The judges will tell you in reading instruction on evaluating a witness's credibility. And they'll talk about corroborative evidence, other evidence that's consistent with the testimony that Sarah Boone gave. So you're going to have to weigh that in her testimony. Now, self-defense, we talked about it in jury selection, usually a gun, some deadly weapon. The suitcase in this case was a physical restraint or a blocking of an attack, but it was unconventional. Self-defense nonetheless. Now, as I said, the struggles that occurred, many of them involve the police. So you're going to actually hear from some of the police officers. Maybe some body cam footage. You're going to see some photographs that they took of the injuries to Sarah Boone. And some of the videos you may see of her in a very happy, joyful type of thing. Well, number one, she's intoxicated. Number two, she's safe. Police are there. So her attitude is not one of distress. You know, we're here today, full packed courtroom. Judge Grayman's here, but you're the most important people. Because you've got to decide this case honestly, fairly, and according to the law. And we talked about the two biggest principles from the Constitution that apply. In this case, and in every case in which a citizen like Sarah Boone is brought into a courtroom and accused of a crime. The first is, you as a juror must presume or believe that Sarah is innocent. And that belief stays with you throughout the entire trial. Because of that, she doesn't have to prove anything. That's why the state went first in jury selection. That's why the state went first today. That's why the state will go first putting on their case. They have the burden of proof, and it's the highest burden we recognize in any type of litigation in this country. Proof beyond and to the exclusion of every reasonable doubt. You are going to have doubts about this case. But the most important thing is not to rush to judgment, to keep an open mind and understand there's two sides to this case. There's their side and there's our side. So you can't form any fixed opinions early on. That's hard to do, as Mr. Henderson said in jury selection. That's extremely hard to do. Now you're going to hear some testimony. There's been mention of experts. Battered women's experiences affect her perception of imminent danger. Battered women's experiences affect her perception of imminent danger. Victims of repeat violence may fear death in a situation others would not. After hearing both sides of this case, we're confident you're going to have a reasonable doubt. And we're going to ask you to follow the law and do justice in this case. And find Sarah Boone not guilty, because it's the right thing to do. Thank you.
Thank you, sir. Can the parties approach for a moment?
He's going to be like, look, let me tell you something. Y'all better stop with these damn shenanigans. And you know how, like at a boxing match, I want a fair fight. I want a clean fight. You guys come out, follow the rules, and that's it. I forget what they say at the beginning of a fight. Remember that? Like, you two get in your individual corners. I want a clean. I want a fair fight. Let's get it popping. No. Shake hands and let's go. Girl, did you see that sorry eyeliner sis had on the other day? I'm like, I guess they did the best they could. You know how it's hard to put eyeliner on people, and she probably doesn't know what the hell to do. He said they were modest. He said they didn't have much money, but they had money to go run buy cigarettes and um wine. They used to drink liquor, but they can't afford liquor and started drinking wine. Do you know the whole time that we knew that they were drinking wine, I did not think for 1 minute that they had got the super big sizes of wine. Either the big, he said a magnum size. Um it didn't even occur to me because that's a party size bottle, or that's like the bottle that you buy
State, you may call the
because
first witness.
maybe, oh, first one. Juan Torres. Okay. Y'all, it's on. Juan before lunch. Now, is Juan Mo? I'm not sure. We're getting ready to find out. Somebody wanted to know which Torres brother was that. We finna to find out if he goes by Mo.
Circuit Morning, you could be seated. And once seated, if you'd state and spell your name for the record for us, please.
Juan Torres, Juantorres.
Thank you, sir. You may inquire, Mr. Cacciatore.
Good morning, sir.
Good morning.
Can you tell us how it is that you know George Torres?
He's my older brother.
And how many siblings do you have?
6 or 7.
And how long has your family resided here in the Central Florida area?
20 plus years.
And before residing in the Central Florida area, were you guys in Philadelphia, Pennsylvania?
Yes, sir. And Massachusetts.
Your brother, how often, your brother George, that is, how often would you talk with him?
Often we talk, say, on a weekly basis.
And how far away did you live from George?
About 5-10 minutes. Very close.
Would you see him pretty often?
I would try not to go there too much.
Who was George living with at the time that he passed away?
Wait, Sarah.
And without getting into many details, what was your relationship like with Sarah?
We didn't really have a relationship.
Would it be fair to say you didn't get along with her?
Yes.
Back on February 23rd, 2020, did you have an occasion to talk to your brother on that day?
Yes, sir.
And when you spoke with your brother on that day, did you FaceTime with him or did you speak with him over the phone?
We talked on the phone.
Was that phone to your ear or was that phone?
It was on speaker.
And who was present?
My wife and my 2 kids.
And without telling us anything that George may have said to you, can you tell us what the topic of that conversation was?
We were just talking like we normally did. He just calling me to check on me, basically.
Now, in the background of that conversation on the evening of February 23rd, 2020, what did you hear?
Sarah's in the background yelling.
And you recognized her voice?
Yes.
What was she yelling about?
Something about choking or how he choked her. I really don't. That pretty much, that was it.
About how long was this conversation that you had?
Maybe 10 minutes, I think it was.
How did the conversation end?
Because she was yelling in the background, so that was it.
Did she sound upset?
She sounded upset.
Did you talk to your brother after that conversation?
No, that was the last conversation I had.
Have you ever spoken to Sarah since that conversation?
No.
I have no further questions.
Any cross-examination?
Good morning, sir.
Good morning.
In the beginning, when you started, it was hard for me to hear, but I know you were talking about other siblings, other family members that you had here. Could you repeat that for me, please?
Here in Orlando, I have one sister and 3 brothers.
Sister and 3 brothers?
Yes, sir.
Okay. Now, did your brother George Torres, did he ever stay with you at any time?
No.
Would he ever live with you or any of, I mean, not you, but any of your other siblings?
No.
All right, sir, let's go back to this phone call that you were talking about that was on February 23rd of 2020. And that phone call was approximately 7:30. Is that correct?
Yes, sir.
All right. And who called who?
He called me.
And then y'all were talking. Is that correct?
Sir.
All right. And when he called you, did you notice anything about his speech or his voice?
No, he was fine.
Sounded normal?
Yes, sir.
Okay. So he wasn't slurring his words or anything like that?
No.
By the way he talked or what he talked to you about, could you tell at that time if he had been consuming alcohol?
No. Because I knew when he would. Drink.
Okay. So in your opinion at that time, based on what you heard and what he was talking about, you do not believe he had been drinking alcohol?
No.
Now, you said you heard Sarah.
Yes, sir.
Is that correct? How did you know it was Sarah?
I can tell in her voice.
You recognized her voice. So you could hear her. Is that correct?
Yes.
All right. And you've heard Sarah speak before that time. Is that correct?
Yes.
And you've heard her speak on the phone before that time. Is that correct?
Yes.
And you said that Sarah was yelling. Is that correct, sir?
Yes.
And she was yelling about, he's choking me. or tell them about choking me.
Yes.
Okay. During that conversation, and you heard her say that, did you ask your brother, what is she talking about?
No, I did not.
Did that statement at that time, did that statement surprise you?
Not really.
You've heard it before?
No.
Based on Sarah's voice that you've heard, was it any indication to you that she had been drinking?
No.
No? Sir, at some point, your brother said he had to go, is that correct?
Yes, sir.
And did he hang up on the conversation?
Yes.
And did he say bye and you say bye?
Yes.
Thank you, sir. I don't have, if I can.
You may, sir.
Sir, other than siblings, your mother and father, do they live in this area?
Yes.
Were there times that George would stay with them?
Yes, sir.
Thank you, sir. No further questions.
Any redirect examination?
No, Your Honor.
Can this witness be released?
Yes, Your Honor.
Defense?
Actually, we'll keep him subject to recall, Your Honor.
Okay.
I would agree with that.
All right, sir. You're released subject to recall by either party. Thank you.
State would call Devin Jamro.
Sir, good morning. You could take a seat and please state and spell your name for the record.
My name is Devin Jamro. That's DevinJamro.
Thank you. You may inquire, sir.
Sir, who do you work for?
I work for Public Supermarkets.
And what is your position with public supermarkets?
I am the assistant store manager.
And at what location?
Currently the Castleberry location.
Were you at the location on Goldenrod and University Boulevard back in February of 2020?
Yes, I was.
Your Honor, may I approach the witness which has been previously marked for identification as states D and been shown to defense?
D is in Delta?
D is in Delta.
Yes, you may.
Sir, I'm showing you it's been marked for identification. This states D. Could you use these scissors and open this and look at the contents of this package to yourself?
Sure.
Sir, do you recognize those items?
I do. Yes.
And tell us, what are these items?
These are Publix receipts.
Are these receipts evidence of transactions at Publix? Are they made at or near the time of each transaction?
They are absolutely made at the time of the transaction.
And is it in the normal course of business that Publix keeps these receipts?
Yes.
And these fairly and accurately appear to be the receipts from your Publix store?
Yep.
Your Honor, at this time, I'd like to move what's previously been marked for identification that states D into evidence.
Any objections?
No objection?
What was pre-marked as states D will be received into evidence without objection as states 1.
I'm not touching my computer anymore.
Your Honor, may I approach the witness who's been previously marked for identification as states J and shown to defense?
You may.
Sir, I'm showing you it's been marked for identification as states J. Can you take a look at that disc?
Yes.
Do you see your initials on that disc?
I do.
Did you have an opportunity?
It's the receipts for the wine.
That disc prior to coming to court this morning?
I did. Yes.
And tell us, what is that disc?
This is CCTV footage burned from the camera system at the location.
And at Publix, is it the regular practice of Publix to utilize surveillance cameras?
Yes.
And in the normal course of business, are the videos from those surveillance cameras kept?
Yes.
And are these the cameras taken from February 23rd, 2020? And I believe there's 2 video clips included, one at 12:17 p.m. and another at approximately 5:39 p.m.
Yes.
And they fairly and accurately represent the surveillance video that was submitted from Publix to law enforcement in this case.
They do. Yes.
Your Honor, at this time, I'd like to move what's previously been marked for identification as states J into evidence.
Any objections?
No objection.
What was pre-marked as states J will be received into evidence without objection as states 2.
And I have no further questions for this witness.
Any cross-examination? Can this witness be released?
Yes.
Thank you, sir. You're released.
Thank you.
Have a great day. State, you may call your next witness.
State would call Joan Williams.
Ma'am, good morning. Could you state and spell your name for the record for us?
Okay, Joan, Joan Williams, Williams.
Thank you, ma'am. Counselor, you may inquire.
Good morning, ma'am.
Good morning.
Can you tell us what it is that you do for a living?
I'm a 911 call taker at Orange County Sheriff's Office,
And how long have you held that position?
24 years.
And tell us, what are your duties as a 911 call taker?
I answer phones for an emergency, non-emergency, medical, which I transfer to the medical side of the business.
And is it the regular practice of Orange County to record 911 calls?
All lines are recorded.
And is it the regular practice of Orange County to keep records of each of those 911 calls?
Yes.
And those records are made at or near the time of each call, correct?
Yes.
Your Honor, may I approach the witness which has been previously marked for identification as states L and been shown to defense?
You may.
Ma'am, I'm showing you what's been previously marked for identification as states L. Do you recognize this disc?
Yes. My initials.
Did you have an opportunity to review this disc prior to coming to court this morning?
Yes.
And those are your initials on the disc?
Yes.
And does this disc, does it fairly and accurately represent the 911 call that you took in this case on February 24th, 2020 at 12:59 hours?
Yes.
Your Honor, at this time, I'd like to move what's previously been marked for identification as states L into evidence.
Any objections?
No objection.
It was pre-marked as states L will be received with no objection as states 3.
Your Honor, I have no further questions.
Any cross-examination?
No, sir.
Can this witness be released?
Yes, Your Honor. Yes.
Thank you, ma'am. Can the parties approach momentarily?
Okay, so yeah, sis came through with her suit, her little Sunday best on. Lamb, could you stop? Lamb is over. Lamb is so. Ooh, come here, P. Come say hi to everybody. Lambo, stop. Lamb, look at Lamb. You can't see him, can you? No. Lamb, come here. Come closer. Stop. Look how tall he is, y'all. Y'all can't see him. This baby. Yeah, you can't see him. He's up here. He's messing with my desk. Leave that alone. Girl. It's doggy daycare in here. Okay. Girl, Portia, come here, P. Come here, baby.
State, you may call your next witness.
Don't talk like that to Bougie game. Oh, my baby. Oh, okay. Okay. Lamb, stop it. Okay.
Sir, you may be seated. After you're seated, if you can state and spell your name for the record for us.
Vincent Battaglia, Vincent Battaglia.
This is one of the neighbors.
Good morning, sir.
Morning.
Can you tell us what it is you do for a living?
Right now I work for an auto parts company,
And where do you live?
New Jersey.
Back on February of 2020, where were you living at that time?
I was living at the Tealwood Apartments in Winter Park, Florida.
And what were you doing at that time when you were living at Tealwood?
I was enrolled in Full Sail University. I was in school.
When you were living at Tealwood, did you have any roommates?
Yeah, I had one roommate, Brandon. Yeah, that was it. Him.
That's Brandon Moats?
Yes.
Did you have neighbors?
Yeah.
Were you neighbors with Sarah Boone and George Torres?
Yes.
And approximately how long were you neighbors with them?
About a year, a little over a year. I moved there in January 2019.
And during the course of that year that you were neighbors with them, did you have occasion to interact with them at times?
Yeah.
In fact, did you ever go over to their home?
Yeah, like a couple times, yeah.
And I believe you tuned a guitar for a child there at the house?
Yeah.
This Tealwood apartment complex, how would you describe the walls that separated your units?
Thin, like very thin walls.
And with those walls being so thin, would you ever have occasion to hear arguing and yelling coming from Sarah Boone and George Torres's apartment?
Yeah.
How often would you hear this?
Almost daily.
Did Sarah Boone ever approach you about the things that you heard coming from their apartment?
Yes.
And where were you when she approached you?
I was smoking a cigarette on my back patio.
And approximately what time
It was
was this?
pretty late. I can't remember the exact time, but it was definitely anywhere between like midnight to 2 a.m., like right around there.
And do you remember how much before the date when the police called that this occurred?
A few months, like probably 4 to 5 months before that.
So 4 or 5 months before February
Of
of
2020.
2020.
Yeah.
And when she approached you on this late evening / early morning on that day, what did she tell you?
Pretty much just kind of like if I do hear anything like through the walls or whatever is out back, just kind of keep my mouth shut. Like don't really speak about it or anything like that or say anything to anyone. And I just was like, okay.
Did she make any motions with her hands?
Yeah, like just kind of like, finger over the lips, like kind of shh, like keep it hush, like that kind of thing.
So she told you not to report anything you may have heard about arguments or yelling or fighting, anything going on over there?
Yeah.
Do you recall the evening of February 23rd, 2020?
I do, yeah.
And what about that evening sticks out to you?
That sticks out to me from that night was literally just there was a very, very loud noise that I heard that was loud and powerful enough to shake my bedroom wall. And I remember that because I was sitting on my bed on FaceTime with my girlfriend at the time, and I literally felt the wall shake and it stopped me mid-conversation. And she even asked me through the computer, like, what was that? And I was like, I have no idea.
Did you hear any yelling coming from their apartment on that night?
Before that, yeah, like it was just arguing kind of stuff.
What was the last thing you heard?
The last thing I heard was like the loud noise and just a little bit of shuffling, and that was kind of it. It just kind of went silent after that.
Could you hear anything that was being said
Not clearly, and it was never really anything clear. It was just like you could hear arguing back and forth, just kind of like and kind of like an I hate you, like it's whatever it is, whatever the argument was about kind of thing. At the time, that's really all it was, but it was never really clear enough to hear like the full argument. And honestly, I never really paid attention too much to it. If I heard it, I kind of stepped into my living room to be further away from it.
Did you hear both the defendant's voice and also George Torres's voice?
Yeah, all the time. It was like a back and forth. Yeah.
So other than the statements and the phrases of I hate you, you weren't able to discern the contents of this argument.
No.
What was the last sound you heard?
The last sound that I heard was like the loud banging noise that it was like a very odd sounding noise that I've never heard before this day, but it very much sounded like it was where my bed was positioned. It was kind of towards the back of the apartment, and it almost sounded like it was coming towards me, but like on the side of me, then it was just like a loud rumbling noise. That literally sounded like it was kind of far away from me, and then it like ended up like almost next to me. And like I said, the walls are thin, so like it's very easy to hear like through the walls, and not even just sideways. Like I hear my upstairs neighbor, like all around, very thin walls.
Now, was your bedroom, where was it located in your apartment?
The back of the apartment, so it was like there's like a little kick out next to my patio, and that's like that was my bedroom back there, like along the grass back there.
On the first floor?
On the first floor, yeah.
I have no further questions.
Any cross-examination?
Mr. Tagley, good morning.
Good morning.
Now, you said that you lived there next to Sarah Boone and George Torres for about a year.
Yes, sir.
Are you aware that the police were called to their residence
Like,
while you were there for the year? Are you aware of any incident in which the police were called to their residence?
I had never seen anybody there, but I had had other neighbors in the complex tell me that it has been on multiple occasions. So that's why.
Just instead of what somebody else told you.
Yeah.
Just what you would observe. Did you ever, the year that you were there living next to them?
Yeah.
Were you ever aware that the police were called to their residence?
No, the times that I was home, I never saw any police at the apartment there.
And did you work odd hours or?
Yeah, and with my schooling and stuff too, I used to have class at like 1 o'clock in the morning. So all the time I was at random moments, like just not home throughout the day and night and stuff like that. So yeah.
Do you have an opinion as to whether or not, based on your interaction with Sarah Boone?
I'm going to object.
Let me finish the question first, please.
Do you know from your experience with Sarah Boone and your experience with George Torres that they drank alcohol?
Yeah.
Hang on.
I'll withdraw to that question.
Okay, thank you.
Yes.
Are you aware that they both consumed alcohol to excess?
Yes.
Thank you.
Hold on.
Yes, sir, of course.
Vincent, I think you had testified, you may have given a statement to law enforcement,
Yes, it was one of the detectives.
a recorded statement.
Yes, I can't remember his name, but yes.
Okay, and I think it was on February 23rd of 2020.
Yeah, right around that time, yeah.
I believe you had said that
I'm going to object this to improper impeachment.
Approach.
Okay. I was trying to clean the top of I was like, why does my mic
Objections
look
overruled for
different?
now.
Okay.
Sir, would it be fair to say on that date you got home around 7? 7 p.m.
7 p.m.
Yes.
Which day was this?
Sunday, February 23rd, 2020.
No, that day I actually got home from work probably around 1 or 2 o'clock or so.
In the morning?
No, in the afternoon, because I went to work that morning at around 5 a.m.
And you said that you heard the normal yelling and arguing at about that time when you got home?
No, it was around that time, but it was really around like 10 o'clock, 10:30 is when like the arguing I could really hear clearly. It was like around 10:30 at night.
Okay. Thank you. Thank you.
Any redirect?
Just very briefly.
Yes, sir.
So on cross-examination, you were asked about the arguing you heard, and I believe your testimony was that it was pretty intense around 10:30.
Yeah.
Approximately what time was it that you heard this loud crashing thump sound that you described?
Little after that.
Overruled.
It was a little after that arguing and stuff. It was probably around 11:15, probably 30, 45 minutes after like the arguing I could hear started.
No other questions?
Can this witness be released?
Yes, Your Honor.
Not subject to recall.
We would like him subject to recall. We've got his number.
Okay.
Your Honor, may we approach?
Yes.
11:15. The first video was somewhere around 11:15. So the suitcase falling down the stairs and her taking the phone out, possibly, that does kind of coincide with, oh, okay, the suitcase just goes down the steps. She takes out the phone and she starts to film it. Because that's around the same time period that it would have, if it fell down the step, if she pushed it down the steps at that time, then it would have gotten down the steps. It would be in the living room. George would be in the living room in the suitcase, and she starts filming. Bitch. I'm just kidding.
All right, sir. You are released, not subject to recall. Have a great day. Thank you.
I love when people from the report start to show up in real life.
State
So we
would call
can.
Brandon Moats.
The other roommate. Here he comes.
Bless you.
Okay, come through, Brandon. Okay, so these are the roommates.
Thank you, sir. You can be seated. State and spell your name for the record for us.
Yeah, my name is Brandon Moats, BRANDON MOATS.
Thank you. Mr. Cacciatore, you may inquire.
Good afternoon, sir.
Good afternoon.
Can you tell us how it is that you knew Sarah Boone?
I moved into the apartment next door to her when I was in college.
And so when was that you were in college?
I would have moved down here in 2019 and would have been there until like 2021, 2022.
So she was your neighbor at Tealwood Apartments, is that correct?
Yeah, it would have been Tealwood back then, yeah.
And did you have any roommates back then?
Yes, I was rooming with Vincent Battaglia.
And during that time, what were you doing? Yeah,
Like,
as far as work and school. And
I was just going to school. During the time of this, yeah, I would have just been going to school. I don't think I would have had my job yet. I was just a student.
Did you have much interaction with the defendant or with George Torres in this case?
Honestly, I avoided them as much as possible usually.
The apartment where you lived, tell us, how would you describe the walls that separated the units?
Yeah, I remember that my bedroom was like the front facing bedroom and our walls shared a wall with where their staircase was. So like the way the apartments were laid out, we had a 1-story apartment, they had a 2-story apartment. So they had a staircase running right next to the walls next to like our bedrooms.
Would you ever have occasion to hear arguing and yelling going on inside of the defendant's apartment?
Yes, the walls were pretty thin. So if people were yelling, you could definitely hear it.
And how often would you hear arguments or disagreements going on over there?
When I first moved in, it was so like it was at least like once a week, to the point that I started tuning them out. Like I got good enough at just like not listening to them. They argued very, very often.
Do you recall the evening of February 23rd, 2020?
Yes, sir.
And on that evening, could you hear arguing going on in their unit?
Not late into the evening, earlier into the evening, probably like 7, 8 o'clock. That evening, probably like earlier on, I could hear arguing.
And where were you inside of your apartment?
I would have been in my bedroom pretty much all night.
And your bedroom, just so that we can paint the picture, where would that would have been, on the first floor or the second floor?
We had a first floor apartment.
Okay, so all the units were, or all the bedrooms were on the first floor.
Yeah, like I was saying before, we had a 1-story apartment, and then they next door had like a 2-story townhouse. So we only had the 1 floor.
Understood. And at a certain point in the evening, did you hear a loud crashing sound?
Yeah, probably around 10:30, 11 o'clock that evening.
And can you describe that sound for us in more detail?
I mean, yeah, at literally, like I said, at like 10:30, 11 o'clock, it's the way their staircase was set up. I could, my bedroom, the top of their staircase would have been like above my ceiling, and it ends next to where like my roommate's apartment was. So I could hear something start above me super loud and then fall away from me like it was falling down the stairs.
Did this affect the walls that were between your two apartments?
Oh yeah, me and my roommate, I remember me and my roommate talking the next day about like we could literally, like, it shook both of our rooms.
Did you ever have occasion to talk with the defendant about what happened?
I never saw her after that. She would have, yeah, I never saw her after that happened.
No further questions.
Any cross-examination?
Good afternoon, sir.
Good afternoon.
Sir, you were asked by the state if you ever had any interactions with Sarah Boone or George Torres. Is that correct?
Yes, sir.
And I think you said you tried to avoid them.
Yeah. I don't like drunk people, and they were drunk a lot, so I did not interact with them.
Do you remember this interaction with Sarah Boone in 2009 when you woke up and witnessed Sarah?
I would have been 9 years old in 2009.
I'm sorry, 2019. Good catch. In 2019, when you woke up and witnessed Sarah sleeping on the concrete patio.
Oh, this may have been a slight misconception in how I said this. I never woke up and saw her sitting on the patio myself. That I would have seen her on the patio eventually, but it's not like I woke up and went back and saw her on the patio. This was my roommate relaying the story that she had fallen asleep on the back patio, and then I saw her.
So you did not witness that yourself, or did you see her?
I saw her asleep on the back patio. I was just clearing up the sequence of events there.
Okay, thank you. Another time, do you recall our interaction with Miss Boone when you were coming home from school and she was trying to talk to you and she seemed paranoid and rambling?
Yeah, I had gotten locked out of my apartment, so I was waiting on the steps waiting on the steps outside of my apartment for my roommate to get home. So she came up and started talking to me. I don't really remember too many details of what she was saying, because I didn't want to talk to her. But yeah.
Okay. Do you remember saying that you believe Sarah was avoiding going into her apartment?
That's definitely the vibe. I don't remember what she was saying, but the vibe she was giving off was that she didn't want to go home.
I believe, and I just want to make sure that I heard you. You said that the first arguments, other than the Boom, which was 10 something, initially it was around 7 p.m. You heard arguing?
It would have, yeah, because it would have been. I remember that day I got home from class around 5, because I got out of class around 4:30 usually and walked home, so I would have gotten home around 5:30, and it would have been after because I came home, I made myself lunch, and I took a shower, and then I heard all of their arguing. So it would have been about an hour and a half, 2 hours after I got home. So around 7 to 8 o'clock.
Okay. And during that time, when you say arguing, was it back and forth?
I honestly, I wouldn't really be able to say if it was back and forth. I don't know I wouldn't remember too vividly if it was back and forth.
Well, let me ask you this. Did you hear a male voice?
Yes, I heard a male voice.
Did you hear a female voice?
Yes.
Okay. Were they both loud?
Yes.
If I can confirm, Judge.
Yes, sir, of course.
Thank you, sir. I have no further questions.
Any redirect?
No, Your Honor.
Can this witness be released?
Yes, Your Honor.
Subject to recall, Judge.
All right, sir, you're released subject to recall. Thank you. Can the parties approach?
I mean, I could relate to the neighbor that you don't want to talk to. We all have at least one of those neighbors that it's like, ew, or oh God, please don't come talk to me. You know what I mean? Even if it's just they talk too long or I'm in a rush type thing. they are long-winded, or I don't want to talk about the lawn today. You know what I mean? Like, it's none of your business where I'm going. Did you guys just get a new refrigerator? No, I'm just kidding. But you know what I'm saying? Like, please don't bother me. Y'all, the spaghetti I made 2 days ago, girl, I put it in the oven. We have like a toaster oven, air fryer, something. It's one of the ones that looks almost like it's like a little mini it's big, but it's not a huge toast. It's not the one with the double doors. Um I love that thing. Ooh, it was so good. There is nothing better than some baked spaghetti. Okay. Ooh. So, Bougie Gang, what's for lunch? Start dropping your lunches. I'm sure they're going to be breaking for lunch soon. Um, and we know that they're planning to go till 5 o'clock. When the time comes later this afternoon, I'll have the feed going, but you know, I'll be monitoring, but I gotta handle business around uh that hour that I normally handle business. You guys understand, right? Girl, baked spaghetti. And what I'm actually gonna do is I'm gonna freeze it. I'm getting because they don't love spaghetti like I love spaghetti. So I'm getting ready to I'm just gonna freeze the rest of it for future lunches. Shrimp Caesar salad. Yum. I think I'm gonna make fried rice tonight. I made rice like 2 days ago and I was getting ready to freeze that. I think I might freeze half of it and cut up some of the vegetables, like some onions, I guess some garlic, and put that in the freezer bag. And then I'm going
Members of our
to
jury, thank you so much for your time, your attention, and your participation in this very important process. It is 12:21. At this point in time, we're going to go ahead and take our lunch break. I'm going to ask that you return here no later than 2 p.m. so we can pick up at that point in time outside of here, 12 Alpha in the Orange County Courthouse. And I'm going to give you an instruction. You're going to hear this instruction a lot over the next couple of days. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors, do not watch local news or read local newspapers. Jurors must not have any discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, please leave your pens and your notepads on each chair. The deputy will collect them. We'll see you at 2 o'clock, and I thank you for your service.
He didn't say we're in recess yet though, right? He said come back at 2. So that's like an hour and a half for lunch. They're probably going to talk about some things, I would almost imagine, right? But it's 12:30, so the clerk, the court stenographer. What do they call her? The court reporter. All right, let's. Are they getting ready? Okay. Okay. I guess he's letting them go for lunch. Okay. Judge left. He looked like he had some law students with him. Hold on. Okay, it's lunchtime. He's got students in the house. Okay, everybody's going to lunch but Sarah. Oh, everyone's going to lunch but Sarah. Oh, Sarah. All right, I gotta go get Portia real quick. Let me go get her because Lambo was okay. Just one second. Let me go get Portia.
Y'all may be seated. Thank you. State, anything we need to address? Defense. All right, Ms. Boone, I just got a couple of inquiries of you, ma'am, before release. Are you satisfied with your attorneys so far throughout this trial?
Definitely.
And are you on board with the strategy that they've employed so far in this trial? All right, thank you very much. We'll be in recess till 2 o'clock. Court's off the record.
Girl, she's going down to the basement and get her peanut butter jelly sandwich. Okay, I think that girl in the gray suit, that's Henderson's daughter. Portia, stop. I can't see her. Portia. Oh, my poo. Okay. You okay, baby? Okay. Oh, look, she's the secretary. The clerk has to handle that big box. That's probably the suitcase. P. Portia. Don't do that with Lambo. Lambo, back up. Give Portia some space. Get up out her face. Don't be a bugaboo. He's trying to kiss her, but she's not interested. Okay. They need to tell Sarah about facial management. And what I mean by facial management is what's called resting bitchy face. Don't have resting bitchy face. Okay. Bitchy face. Okay. All right. So I guess should we shut this one down? Oh, I hate to have to shut it down, but why be dormant for a whole hour? Sarah, go ahead and get your shackles put on. Girl. He's like, okay, we'll see you in a little bit. We're getting ready to go down to the steakhouse for a nice lunch that you're not paying for as a client. So we can't take you out for a client. We can't take you out a la Karen Reed. You see the difference between look, two murder cases, well, it is two murder cases where alcohol is involved. Karen Reed is a college professor. She goes home every day, her hair done, makeup done, all of the things. I don't know. We really should have a conversation about that. The difference, I mean, maybe is it coins versus no coins, lying versus not lying, but Karen Reed didn't necessarily, even though, there is a network of people who have a vested interest, so it seems, in seeing her go down. Um, she hasn't been called out for a lie, but there have been other people caught in lies too, right? Um, why is she still sitting there? Where is law and crime overseeing Miss Boone right now? Who are these people? Hey girl, you need some help? They said you need some help. You want okay, what do you need for us to do? Okay. Hey hey Lydia. Girl. Oh, and the prisoner's still sitting here? Why didn't they show us with the shackle shuffle? Oh, girl, did I was over on YouTube. Girl, I could see you clocking in your the evidence. Where is her handler? Where is Officer Shackles? Okay, where's Awful Shackerford? Okay. Y'all, we probably could go on till 2 o'clock with the jokes, but we're not gonna, okay? Um What else did I want to talk about? Girl, the shackle shuffle. Girl, let me tell you how I so want to take a little nappy poo. Girl, do you imagine? I come back at 2 o'clock, like, y'all, okay? Like, it's look, let me give my recap right now. Okay. Okay. This is my recap so far. Y'all, we've been live for 4 hours, okay? Um, number one, the state is not playing on these witnesses. They've already gone through Juan, Publix manager, 911 operator, Brandon, and Vincent. They've already gone through 5. The witness list for the state is 50. In the first hour, was it 11:30? It was, let's say 11ish, 10:30, something. Let's just say in 2 hours, they've gone through 10% of the witnesses already. Did I miss anybody? One, Publix manager, 911 operator, Vincent and Brandon. Yeah, Vincent and Brandon. Brandon Moats, Vincent Battaglia, come through suit, fresh haircut, and Juan Torres. Okay. Yeah. 5. Brandon said I don't like drunk people. Okay. So we had 5. Brandon and Vincent can kind of set the time that we think that this is what we don't know or don't understand. First of all, let's just take Sarah's narrative, okay? Sarah's narrative is they were playing, they were hide and seeking, they were doing arts and crafts, they were doing, it's not my fault. And all we have is her story. So her story is I was in the shower. We don't even know if she went in the shower. Let's be honest. We don't know anything of what she said. We don't know actually happened other than they were in the apartment. They were arguing. George died of positional asphyxiation, more than likely from suffocating in the suitcase. Again, we have to take her word for everything. And according to Mr. Owens in his opening statement, she lied. Hello? She said she lied. So what'd you lie about? Have you lied about everything or you lied about some things? That's what I want to know. Is it all a lie or is it some lies, right? So that's what we know. That there was a lie. Now her lawyer says she lied. We know they were in the apartment. We know they were arguing, and we know George is dead. We know he died of positional asphyxiation, so it would make sense that he was in the suitcase, and he died in the suitcase at some point. We don't know when. She said 11 o'clock, something like that. She wants us to believe that her ass was drunk, and she got up 12 hours later to not knowing where this guy is that doesn't have a phone, doesn't have a job, doesn't have any money, doesn't have a car, and doesn't seem to do anything without her. So where is he? Oh, I don't know. It seemed like it was a situation where he was in your ass, right? Because he didn't have a job, he didn't have any money, he didn't have a car, he didn't have a phone. Who in the world could he be cheating with? Okay. Who can a man who doesn't have anything going on cheat with? A bum, right? And I mean, in theory, Sarah is a bum too. Let's just be serious here. She's not a 5-star chick. She doesn't have a whole lot going on for herself. She's, she's living off of a check from her husband, and it's not a generous check. Okay. They are living in a thin-walled apartment, which is probably ideal for students because we see who was living there. Young people who need cheap rent and a decent place to live, right? She's living there in her 40s with her boyfriend. They're both unemployed. Okay. Now, as far as y'all, oh, they're so annoying. We don't know. We don't know what she's saying is true. We know there seems to be some speculation that George was probably in the suitcase upstairs and she threw the suitcase downstairs. So the premise that I was in the shower and I went downstairs, that's a lie because you were in the shower. She, at a certain point, there is a narrative where she says she was sick of waiting in the shower. She got mad. She was waiting in the shower. He never came to get her. So either he was already in the suitcase, quote unquote, hiding, and it was upstairs. And she was like, oh, but you were supposed to come get me, but I found you. And then she got mad. She got mad. She was in the shower. Lambo. I'm sorry, y'all. She got mad. He didn't come to find her. She saw him in the suitcase. She zipped it up to be a bitch and threw his ass down the stairs. Oh, you didn't come looking for me? We didn't drink half a gallon of wine. What? Beat him with the base. Why was the baseball bat downstairs? If Lucas's stuff is upstairs, if Lucas's bedroom is upstairs, Lucas hadn't been over there in 2 weeks. Okay. Because I've read the case file. Lucas hadn't been over there in 2 weeks, right? Why is his bat downstairs? After George broke your TV with the baseball bat, you didn't go put the baseball bat away? You left it out? Wasn't the suitcase supposed to have stuff in it that you were donating? So where's the stuff that was supposed to be donated? Was it in the suitcase? Was it on the floor somewhere? Like, where's the stuff that was supposed to be donated? Where did you get the suitcase? Where did the beating happen? Did you beat him upstairs? Did you beat him downstairs? Like, I got questions, okay? I think she was in the shower. She got mad. He didn't come find her. She found him hiding in the suitcase in the hallway where they were supposed to be putting clothes together to be donated. And she zipped his ass up. She went in Lucas's room because she was mad. She was drunk. She got the bat. She beat the shit out of him. And she kicked the fucking suitcase down the stairs. And then she continued the shenanigans on the floor in the living room, took out her phone with her drunk ass talking about, that's what you get. You know what I mean? That's what you get. That's what you get for hurting me. That's what you get. That's what you get. Okay. Once they enter in an overt act, they have to be able to articulate that something happened to make her scared for her to use deadly force, or for her to use that there was some sort of an aggravated situation to make her use force. That's when they're going to get that in. They can't do it until there's something that's said and there's no evidence that the defense can present other than Sarah to present the battered person syndrome, battered person defense. You have to be in a volatile situation to say self-defense. So we just gonna have to wait for it and trust the process. Okay. We gotta wait for it and trust the process to know, well, we know what's getting ready to happen because we've been here, right? We know even more than, like, forget about knowing more than the jury. We know a lot. We know right up under the prosecution and the defense, because if you've been reading the documents, reading the police reports, we've seen the videos, we've seen the dash cams, we know more than the judge. I mean, the judge knows the law, but the judges aren't researching these cases. He knows what has been presented to him so far. He knows what the narrative is, but in order for him to not formulate opinion, unlike the weirdo Sonia Durham Waller, who seems to think judges should be researching cases, judges can't research the cases because it has to be what the prosecution delivers and it has to be what the defense argues. They can't go get evidence to try to formulate an opinion. Like, the judges don't research. The judges hear both sides and make sure that there is a fair trial that occurs. Or if if there's no jury, then they make the decision, right? They make the punishment, the guilt. Well, I guess this is called the guilt phase, where they determine whether there's guilt, and then there's the punishment. Didn't they say that Mr. Owens has some proof she was in danger? The proof that he says is that George's finger came out of the suitcase, and that was the overt act. She was scared at that moment after she had fucked with him the long way, allegedly, that after she messed with him, after she locked him in a suitcase and he couldn't breathe, at a certain point his finger came out, and to her, that was the overt act, because she was afraid he was going to get out. So she beat him with the baseball bat. That was the overt act. He was trying to get out. He was trying to not suffocate. Maybe he would get out and later beat her. I don't know. You know what I mean? I was raised on some don't start none, won't be none type stuff. You know what I mean? Leave people alone. Treat people how you want to be treated, right? So you zip someone in a suitcase who you have a tumultuous relationship with, and you expect them to not be who you know that they've been consistently for years. Not to mention, I'm gonna put that on George too. You engage with Sarah knowing that she's a violent drunk. You're a violent drunk. She's a violent drunk. And you guys decide on this night you're playing and you guys are going to get drunk. Probably not a good idea, right? And unfortunately somebody died. In this case, it was George. I don't know. You guys think about it. I'm going to set up the next live. I'm going to shut this down. I'm going to set up the next live. And I think I'm going to take a little break and see if I can get these dogs to calm down a little bit, and throw some balls outside and let Lambo get some exercise. And I think that's it. I'll set up the next live. So if you guys give me a second, I'll do it while you guys are talking. Or I guess while I'm talking to you guys. Yeah, so I think that's, I mean, I don't know what else to say. I just think that they have to, I think that obviously what the defense is going to do is that they want to provide some sort of reasonable doubt. And I get it because that's their job. Um, I just don't know if when they put Mr. J needs to relax and just be cool because his agitation at Owens, he needs to not give a fuck. And I don't mean about this whole thing. He needs to not give a fuck about them not following the rules. People who are very much rule followers, it bothers them when people do exactly what they're supposed to do. It really does aggravate people who when people who don't follow rules, it aggravates the people who do, right? Like, it's not fair. Why would you do that? Da, 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 da. Owens is testing Mr. J's sensibilities, I feel like. They're doing sloppy work. Either they're doing it sloppy or they're on purpose or because they're sloppy, right? We don't know. So they've already had a Richardson hearing. The judge basically let them slide this time, but I think if it happens again, they'd probably have to look at it again, and maybe they don't get to put their evidence in, stuff like that. Mr. J just needs to like be cool and just do your case. Do your case and handle the battles. You know what I mean? Present your case and handle your battles. Because at the end of the day, the truth will always win. And I think that they seem to be very well prepared. I wouldn't want to have to mess with them folks. I really wouldn't. So, as far as what they have to work with, I think they have 4 years worth of evidence. And I think that it's their case to button up. And I think the state of Florida has the advantage. And I just think that James Owens is there to be a disruptor. That's what he came in on. He came in on some disruption and some aggravation and things of that nature. And I don't know, should I even, I see law and crime is still up. It's like, should I just shut this down and start a new one or just leave it? I don't know. Maybe I should shut this down. What do you guys think? It just makes for so many lives off work. Let's see. Did they go off of the seal? So they turned off the feed. Are you guys staying here to chat? Let me see. What music do there's no music on here. I took all that god awful StreamYard music. I took it off. Let me pull up Epidemic Sound. Let's see. Girl, let me tell you, it's like freaking dog kinder care around here every day. If you guys only knew. Epidemic Sound. Let's see what's going on. Epidemic Sound. Okay. So did you guys, I really didn't want to talk about this right now because I figured we'll talk about it on a Nesto Live. Search by video. What is that? So Epidemic Sound has a select or drop a video. Oh, okay, to be able to identify the music. Okay, well, we're not doing that. Some of this stuff you do not want to hear, okay? All right, let's see. Mm-mm. You guys will be mad at me. Epidemic Sound is only reason why I have Epidemic Sound. It's for the random video, especially more on my other channel, the random video with the random music and trending TikTok. Let's see. Okay. Awesome. Girl. No. Okay, it's awful. Okay, this is what I'm gonna do. I'm gonna start the new live, and I do kind of want to shut some of these. I'm gonna just shut them all. I'm gonna just bite the bullet and shut everything, and I'm gonna do it nice. Let my computer sit for a minute, and then I'm gonna also go get my other computer. Um, I don't think I'm gonna swap yet. I don't know what's I don't think I'm gonna swap, but seemed like it got better in the afternoon. But yeah, let me do a complete reset. Let me go ahead and set this up so you guys can go and chill over there. Um let me copy this description box and you guys can go hang out in the other live and I will start it back. They told the people to be back no later than 2. So I don't know if that means they're starting sharp at 2, but I'll set this for 1:55. 1:55. I'd almost feel like if they're back at 2, it's because they already know. I need to go back. Did you guys hear when he said that how long lunch was going to be? He told the jury to not be back any later than 2. I don't know that they had anything to argue when they came back from lunch. Okay. Let's see what they said. Delphi update per pool in the courtroom. Judges confiscated 5 still cameras and 1 video camera and kicked out AP and NBC network for the duration of the trial. Judge said they were filming jurors. What? Delphi update per pool in the courtroom. Okay, did you guys see this on Court TV? Per the pool. Hold on. Oh, they're playing some sort of music. Okay. Okay. Let's see. Per Delphi update, it says per pool in the courtroom, judge. Oh, Delphi. Okay, that's another case. I was like, what happened? But they said, so Delphi update per pool in the courtroom, Judge Gull has confiscated 5 still cameras and 1 video camera and kicked out the AP and NBC network for the duration of the trial. Judge said they were filming jurors. Oh, well. I mean, you gotta be on the honor system. If you can't be trusted, we don't need to have you in here. So your bosses get to talk to you about honoring your word. If we tell you we don't want you to film something or someone, then that's just what it is. Who is this person? Oh God. Okay, I guess someone's just dropping off a card. Please don't ring my bell. This man came disrupt my house. Oh God. I'm not answering the door. This guy just came, knocked on the door. I guess he's dropping off a landscaper. He's like a landscaper or whatever. And I mean, I'm sitting like literally right here. I can see everything. And anyway. Hold on one second. Okay. He just dropped a card. So he came, rang my bell, was holding up a business card, like I guess so I could see, like, hey, I'm okay. I got a business card. I'm not, we don't need any help. It's like, sir, would you buy? See, this is why I sit in this office, because I can see everything that's going on. You know what I'm saying? I'm well positioned in the house, so I can see what's going on. Anyway, okay. All right, let's reconvene in a little bit. All right, so the live is up, guys. Do you guys want me to drop you a link to it? Oh, let me redirect, right? I'll shut this down and redirect you guys over there. And then just hit the notify me button. Hit the notify me. So for tomorrow, I will set up like AM, PM. That way we won't have this problem again. Okay, guys, enjoy your lunch. I'll see you guys back in like an hour. Okay, I'll see you guys.